Mhm. There it is. So,
All right. So that we have a criminal trial calendar to call, and the goal today is to see which cases are working out, and those that are not resolving, we'll figure out the order in which they'll be called out on Monday. Trial would start on Monday, the 12th, for cases that are not resolved today. We'll call the trial calendar and we'll see what the line looks like for pleas today, discussions, pretrial, whatever it's going to be. Before we take any of those, I've been asked by the sheriff's team that we do Mr. McCrary's plea. So I trust your trial partner will be here soon.
In the building.
Good, excellent. But we'll call the trial calendar and then we'll dive straight into Mr. McCrary's plea for whomever on the state side is going to be handling that. They would like to get him going wherever he's going as a result of the plea. So with that, trial calendar, positions 1 through 4 are Mr. Beck, Demetrius Beck.
Good morning, Leslie.
Hey.
On behalf of Mr. Beck.
How are you?
He's not here. I just got a text message from him saying he's in the hospital. I responded back. I'm not sure if he's admitted, if he is in the ER. I don't know if you recall, but at final plea, he was excused because of a medical issue. We were supposed to meet multiple times after that. He's had to cancel on me multiple times because of health issues. I think they are legitimate, but I don't have any documentation at this time for the court.
Got it.
I will say this, we received an offer, local offer from the state. My client did reject it. To be frank, I don't think it should be a trial, it'd probably be a non-negotiated plea. But I haven't even had a chance to go over the discovery. He's had, like I said, multiple.
Sure, you need him to have those discussions. Well, a couple things. The state shared with me that if it is a trial, they let me know which one they'd go forward with first. I want you to know that. It's position 4 on the calendar. It's the indictment that ends in 641. 641. It's one of the 2 robberies. There are 2 robberies and then there's criminal damage cases. So, okay, so 641 is what the state will go forward with. Of course, we need a defendant to do that. So that's point number 1. Point number 2 is Mr. Beck or his family needs to get you something you can get to me or Ms. Nelson. Obviously, I'll share it with the state, documenting that he is where he says he is. Otherwise, I'll need to do a bench warrant and then we'll get him in a place where you're able to meet with him and we can figure out what we're going to do. But I certainly, his health comes first. And so if he is, there's a legitimate issue that's being addressed, then that needs to be addressed and then we'll work through his cases.
Obviously, I'll let the court know as soon as I, get word.
Okay,
Okay.
great.
Can I be excused?
Yes, as long as you will work on that and just know that probably in an hour or so, if we haven't heard from you, I'll request the bench warrant. I'm always happy to set it aside if at 3 today from Dr. So-and-so, there is a letter or something saying he's incapacitated and he shouldn't be here. He needs to be dealing with whatever he's doing.
Of course, outweigh judge, but they're holding me in Clayton County.
Go to Clayton County.
So,
All right.
I'll keep the board informed. Thank you.
Thank you. Okay. Good morning. That gets us to position 5 and 6, Marquise Sinkfield. Now, I know Ms. Taylor, this time it's the lawyer with the medical emergency, she was unavailable. Mr.
Yesterday.
Okay.
She said that she did inform him.
That he needed to be here.
And she was gonna try to get someone to fill in for her.
Okay. Mr. Miller, do I ask you or Ms. Smith about what's happening on the state side with with Sinkfield. And by what's happened, I just mean if anyone has had contact with Ms. Taylor about some type of non-trial resolution.
Yeah, I spoke with her about a global resolution in the
Okay.
cases, but we haven't come to any type of solution.
All right. Well, I'll give Mr. Sinkfield a little while to get here, but he was informed through counsel that he needed to be here, even if Ms. Taylor wasn't going to make it. It sounds like she was working to get co-counsel to be here, maybe to speak with you and Mr. Miller about resolving it or not resolving it. But we'll see. All right. At this rate, we won't have to worry about having a trial. Position 7 is Duranta Jones.
So she's mine. I didn't see him, but I do expect him.
You expect him?
I will.
We'll hold.
Reach out.
Okay. Dontavius Wright is in custody and his lawyer is not well and was going to appear virtually, but I don't see him online. Good morning.
Morning. Judge, that is correct. I did see the emails that he was gonna pop online, but it's my understanding that we're still waiting on the evaluation. We don't really have anything else to add. I guess the state would just wanna know, is this gonna be pushed to the February calendar then, or is there a date in between there that we should worry about? Just wanna make sure for subpoena purposes.
Sure. We were able to dredge up the email from Ms. Green, Zarina Green, who manages the logistics of the work that still needs to be done. And there was a little hiccup, and Mr. Wright, it took 2 interviews, but the second interview is done. And so we're just waiting on the report with a due date of mid-January. That's how it was described. And I haven't seen it yet. I'll get it as soon as it's done, as will Mr. Johnson, and then he'll decide where that takes things. So no to this calendar. I don't think Mr. Wright was on the February. Isn't February with Hairston?
Yes.
So it will not,
And I was gonna say, he was not on it. I just didn't know if he was gonna get added to.
no, it would go to the March calendar.
Okay.
All right?
Okay, and I believe that concludes my business. There were 2 other positions, but those are gone now.
Gone now as in you resolved them?
Yes, one went to, one other position, and it went to a diversion. Miss Woodson,
Yes,
and
they,
she's reset for August.
okay, to see how she's doing.
Correct.
Great, thank you.
Thank you.
Deputy Gordon you're not Deputy Gordon. Hi there.
He's downstairs.
He's getting the inmates. Okay, thanks. Brandon Baker and Ricky Pierce, they will be brought up. And Mr. Abadi, you were going to be speaking with Ms. Cabrera, who I think said she was going to make this her first stop. Okay.
Yes, she's on her way.
She's on her way for her first stop. Okay, so we'll hold on those. Corey Comer.
Good morning, Your Honor. Latoya Williams on behalf of Mr. Comer.
Hey.
Hey, good to see you.
Same.
I informed the state on yesterday via email that I was missing some things from discovery. I filed a conflict letter, and my file was continued, so I did appear this morning. So I did not expect to be here, but I did inform the state that I was missing some things from discovery, or some things were not working from the discovery link that they sent me. And I'll pander to the court, they did send it some time back, and because I was working on this double homicide in Carroll County, I had not gotten the opportunity to really go through it. But now that I have, I can be ready, but I just need those missing things from the discovery.
Okay, well, thank you for being here. I'm glad, did your other case resolve or it got continued? Oh, all right, so it's still out there. Can you just give me a sense of the nature of what it is that you you still need to, well, I guess I'm a little confused by what you said. Did you learn that actually they did send it and you just hadn't been able to see it, or you have confirmed you do not have it?
I I confirmed I do not have these things.
Okay, so help me understand the things, is it a statement from your client? Is it a
There are
cell phone?
dumps.
Oh, okay.
They have provided me with an Excel spreadsheet of sorts that kind of tells me, but I need the actual raw data.
Sure.
To sell right and look at the things myself.
Yep.
There are, just here, there are 3 files that aren't working, that they're supposed to contain police reports. There are links, but those files don't work. I have the search warrant affidavits and the actual search warrant, but not the return or any property sheets from anything that they found. DNA testing that was done on a fork that was found, at the scene. Any further testing, now the further testing on the shell casings, I'm not sure if it was done, but that's just something that I expect to see, and so I included it in my list, of things.
So cell phone extraction,
Yes,
a couple police reports, hopefully not the lead detective's main report.
I have supplementals is what I have.
Okay, well, whatever they are. You've got the search warrants and you've got the affidavits. You just don't know what, if anything, was seized as a result of the search warrants.
That's correct.
And are those search warrants of residents, or is it like a search warrant for a buccal swab, in which case, you know what they got? They got a
No,
buccal swab.
for an apartment.
Okay. And then maybe there was some DNA done on a fork from
I
your,
know that there was testing done on the fork to prove that there was saliva on the fork, but then the report says that there needs to be further DNA testing to see if that matches someone, and I don't know if that was done.
Mhm.
And if it was, then I need to look.
got it. And then an inquiry into, was there more ballistics work done on shell casings? That's it.
Yes.
Okay, got it. And I don't mean that's not much or it's a lot. I just want to make sure I've got a complete list. Okay. Mr. Abadi, when I asked him purely procedurally, hey, how long do you think this case would take? He said because there are 2 decedents in the case, it's probably not we can do it Monday through Friday. It might spill over into a second week. I know you don't have all the discovery yet, but based on what you have and your discussions with Mr. Comer, do you agree that it probably is a case that we would be pressed if we were trying to be done by a Friday if we started that Monday?
Yes, Judge, I agree.
Okay, that'll just help me figure out the right place to put it on a future calendar. I'm anxious to get Mr. Comer into court when we can, and your schedule is complicated. So we've got you right now. I don't want to let you go, but it's a 1-week trial calendar, and you need to get these things. Now, have you been co-counseling? I think there's been a colleague of yours who's been in court a couple times, Ms. Smarch.
Yeah, she's the junior attorney in my.
Okay, but if
So I've been sending her if I can come, but she would not be, she's last year graduated from law school, so she would not be able to try the case if I were not available.
okay, and that's not why I was asking so much. I just want to make sure if she's here in your stead for a call of a calendar or something, we can make progress with that. Okay, but if it's a trial, she might be there to help you, but you're lead.
Absolutely.
Okay, got it. Mr. Abadi, are you familiar with these discovery concerns?
I am, as of yesterday when she sent the email.
Okay.
The concerns, I hadn't had a chance to reply, but the ballistics report was sent via Georgia e-file, 12/23 of last year, so
And that'll take care of the shell casings?
yes.
Okay,
And then as it relates to the cell phone dumps that she described, the reason they're extractions, they weren't dumps, they were search warrants for cell phone records. So that's why it's the Excel spreadsheet.
okay, so as opposed to Cellbrite, that kind of notion where your team would have pulled stuff off a cell phone, it's Verizon saying, here are the records showing call detail or cell tower information for phone number 1234 for some time frame.
That's correct. I know there was a phone collected on one of the scenes. I'll find out if there's an extraction done on that phone, but there's nothing in the state's possession as of now as it relates to a cell phone extraction.
Okay,
I don't have
and
anything from Verizon, like even, all I.
I made up Verizon. I don't,
Well, I don't have any, all I have is an Excel spreadsheet that looks like it was done, maybe by the state or whatever, like, because it didn't have the complete information, it doesn't even have the IMEI numbers or anything like that that I would expect to see.
okay,
And so that's why I thought that it was incomplete.
Okay, and it may be that what was pushed across to you was the summary spreadsheet, and you're certainly entitled to the raw data behind it. So I'm sure Mr. Abadi will check on that. What about the fork and DNA work on that?
No further testing will go on that.
Okay, so the state's presentation would end with saliva was found on the fork,
If that was.
if that's what it said, but there's nothing beyond that.
Yeah.
Okay, and then I guess you'll be working on trying to resurrect those police reports where the links didn't work and whether there was a search warrant return. And those all sound like things you or someone working with you could get out the door pretty quickly.
Yes.
Okay.
There's no returns. They don't do those.
Okay, well, you're going to be responding, and it sounds like Ms. Williams, by the next time we get Mr. Comer's case on a calendar where we've got more than a week to work with, you will have received all this, and you ought to be in a position to move forward. Plus, other than the police reports, it doesn't sound like any of it is the kind of thing where you're going to say, I need an expert in 6 months to digest all that. We just need to make sure the police report doesn't reference something that you also don't have. Okay, Mr. Comer will be here in a little bit. Do you want to stick around so you can talk with him? Okay, I always offer this, if it is helpful after you talk to him, to have him come out so he can hear from the judge, here's what's going on. That's great. I don't require it, but people sometimes say I came all the way over here and I didn't even come out into court. So if it is helpful for your relationship with him, for him to come out, I can say, here's why we're not going to be able to do your trial next week. I'm happy to do that. Okay, so just let me know. Mr. Abadi, anything else on the Comer matter?
There.
Okay, thank you. Antonio Burden.
Would you mind? He sent me information this morning. He had car trouble. He's in a lift and he was 18 minutes away, about 6 minutes ago. So-
Okay. All right. Nevada Twitchell,
Mr. Brown.
how are you?
I'm still waiting on the council.
Yeah, we're voting for his.
Okay, he's let us know he's on his way. Kendrick Brightwell, we've resolved. Hopefully you're not here, Mr. Brightwell. Nope. Aaron Michael Pendleton. Okay. Is this one where he said he had a conflict? You mentioned,
He filed a conflict, in looking back at it after the other day, I think it's for him and his father in one conflict letter. So the medical on the 7th, I think is his dad,
could be his dad.
and the trial week is him.
Okay, so then
I don't know.
Mr. Cook Jr. ought to be here today, as best you can tell.
Well, I think the trial week is him, the son,
Right,
this Mr. Cook.
well, correct. The trial, but today is not the trial week. So today, Mr. Cook, the son, ought to be here.
I thought it was the 6th through the 9th or the 5th through the 9th.
Oh, they just happen to overlap. Oh, I see. I'm not remember, now I'm remembering, is that we were
Right.
both confused as how do you have a medical situation in the middle of a trial week?
Correct. And I think Tim Cook has the trial week and his father has
The medical situation. Well, let me ask Mr. Pendleton. Mr. Pendleton, when you reached out to Mr. Cook, did he say, yeah, I'll be here, I'm just running a little late? Did he say nothing or?
He originally said that he was gonna just be running late today, he had an issue over in Marietta.
Okay. Then we're gonna reach out to him as well, and we're all gonna sit tight and hope that he can make it. He can always hop on the Zoom, but he needs to certainly have a discussion with Ms. McGillicuddy about the situation. Okay, thanks. Winfred Sherman is in custody. He's got 2 positions. Ms. Wood?
He should be pleased. I just need to speak with him briefly.
Okay. And Ms. Smith or Mr. Miller, you are not surprised that they're going to be pleased?
No,
Okay. All right. I hope someone, I'll try to look it up. He tried to plead before, and I need to remember what I said before, so he's not thinking like, why are you changing your mind? So maybe someone wrote that down.
A different negotiation.
Okay. All right.
Very.
Thanks to Mr. Sperry. All right. But he's not here right now. Number 18 is Layla Faria. Good morning. Your lawyer is going to be here. So we're going to wait for her to arrive and then talk a little bit about your case, okay? Thanks. Isaiah Gates. Hello, Mr. Gates. Your lawyer, Mr. Walls, is on the call and is very graciously taking time away from a break that he has. And Ms. Nelson told me that maybe it's a plea. I don't know if either prosecutor spoke with Mr. Walls. I know we've been working with him because he was pointing out he had to leave.
I spoke with him, Your Honor.
Okay.
Expected to be a plea.
Expected to be a plea? Okay. Hey, Mr. Walls, good morning, sir.
Good morning, Your Honor. Yes, that's correct. It's suspected we were able to negotiate a plea for this morning, Your Honor. I will ask that the court prioritize my plea deal today, considering that I'm on leave.
Yes. I don't know when you got on the call. The first plea we're going to take is a gentleman in custody, Mr. McCrary, from yesterday that I need to do, and then we'll do Mr. Gates's.
Thank you so much, Your Honor.
No. Least I could do. I appreciate you making yourself available, and I think it's going to help deal with a couple of defendants in this case. So
Yes.
You can be at ease for a little bit. We're almost through this calendar, and then, like I said, we'll do the McCrary plea, and then we'll do the Gates plea.
Okay, thank you again, Your Honor.
You bet. So Mr. Gates, we'll circle back in a minute, and when it's plea time, you'll come up to the podium. We'll have your lawyer right there on the screen, and we'll go forward, okay? All right, and then the third defendant in that case, Mr. Lewis, I don't think we produced from DeKalb, is that right?
No.
Good. Okay, we'll see what happens with that. Charlie Daniels.
Morning, Judge.
How are you, Mr. Majeski?
Happy to be here, Judge. Judge, he's here, obviously, he's standing right there. Only issue out of this case, and we were here last month. In the beginning of December, I had mentioned that there was a video referenced in the discovery supposedly capturing this incident. I spoke with the state about it. They said it does exist, but they don't have it yet. It's gonna be dispositive. I'd really like to see that before
Okay.
I do anything with it. Can we put this on the February? Because I think the state will be able to get it fairly quickly. I mean,
So February's full, but why don't you share an update, Ms. Smith? If a month ago you knew this video was out there, I'm sure you've been trying, but tell me what the holdup is.
Yes, Your Honor, we spoke with the victim in this case, who was the one that would have possession of the Ring doorbell camera. However, since it happened a while ago, we're not sure if it exists. She said that it does. I'm just waiting to get it from her.
Got
To see if it's still in the database because it happened a while ago.
Okay,
So it's not something that's in the state's possession, and we're not too sure if it's in the victim's possession.
got it. It's not the police have it or body cam video, or it was at the Citgo station. It is the alleged victim saying it was on Ring, or it should have been on Ring, but not necessarily anything anyone has ever seen. Okay,
We can try to confirm as soon as possible if it even exists, and if not, we'll let Mr. Majeski know.
okay. Is your channel of communication with this person good enough that you'd be able to reach out this morning, or is it kind of spotty?
Yes, I just spoke with her like a day or two ago.
Okay.
So I'll call her this morning to see if she answers.
So why don't we do that?
okay, Judge, the only request I have with that is I got a case from like 6 of your colleagues.
Okay,
4 of them are also trial candidates,
Mhm.
making that success. So could I do that while they're doing that, go make my rounds and come back?
yes, sir, you can do that. And if you'd leave your cell number with Ms. Nelson, we might pull you out of that cycle that you're in if there's a development, so you can come back. But I know you'll come back if you get through it and you haven't heard from us.
Sure. I'm gonna be in the buildings, all this full stuff.
Okay.
Can I approach and give that to Ms. Nelson?
Yes.
Thank you.
Yes, please. So, Mr. Daniels, Mr. Majeski can chat with you for a second if you'd like, but I'm gonna have you sit tight, and we're gonna see if we can get a real-time update from the prosecution about the existence of this video. And if that person says, yeah, I thought I had it, but I don't, then today's the day to figure out what we're doing with your case. Okay? This is an elusive trial calendar. All right, 22 is pretrial diversion. 23 is Tyrone Patterson. Oh, we're now getting into this case. So is Mr. Patterson here? Great, you can take a seat. Is Ms. Harrigan here? We'll hold for Ms. Cabrera, but Ms. Harrigan does need to be here. How about Ms. Francis? Good morning. You have all sorts of people here with you.
Good morning.
Good morning. All right, and how about Raheem Smith? He's here, great. And last but not least, Mr. Bradford.
Good morning, Judge. Mr. Bradford is here.
He's here.
Yes.
Okay. And Mr. Luemba, is this the person you and I talked about? Okay, just want to make sure we're all connected. So really all of the defendants are here except Ms. Harrigan, who does need to be here. Her lawyer's not here yet, so she may have an explanation for that. Ms. Smith or Mr. Miller, is the state ready on this case? Is there anything that's changed since we last talked about it? I know we had final plea, and I think to a person, the defendant said no to what the offer was.
Yes, Your Honor, right now the current offer is still the same, which is at 15-13. We are ready to proceed. However, our only concern is because of the amount of co-defendants in the case that it'll go and extend beyond a week.
It would. I think that's right. And so I don't want to keep the lawyers and their clients around any longer than we need to. I guess let me just cycle through. So Ms. Rios, do you represent Mr. Patterson?
Yes, Your Honor.
You have any discovery issues?
I don't believe so.
You're good to go. When we can get a trial date, there's no reason you shouldn't be ready to go.
Yes, Your Honor.
Okay. Find out about Ms. Harrigan. And as for Ms. Francis, how is discovery looking?
We have all discovery on.
Okay.
Discovery issues.
All right. And will you be co-trying the case?
Yes, Your Honor.
So we need both of you to be available.
We do, and I think I've served the court or sent the court emergency leave of absence for next week. I've got a death in the family. I'll be out of the country.
You will, and that's exactly where you need to be. I'm sorry for your family's loss, and I appreciate you being here today, but you certainly need to attend to that.
Apart from that, whenever you're able to put us on trial calendar, we are ready.
You'll make it happen.
And we're eager.
Don't be intimidated, Ms. Smith. That's just how he talks. Okay?
And what is for, notwithstanding there being a good number of defendants, I actually don't think we're going past them.
Okay. All right. But it can't be next week because you need to be doing what you're doing, because I think everyone's on bond, that's the right way to prioritize things. Okay. You're awfully optimistic that 5 defense attorneys taking a crack at each witness and we'd be done in a week, but who knows? Voir dire will take 6 days.
No. We'll knock it out in a day.
All right. Did everyone hear that? One day.
I've seen the evidence.
Okay. All right.
I think that's good.
All right. Well, thank you, both of you, for being here. If you'll take a seat. Mr. Melnick, on behalf of Mr. Smith, anything keeping you from being ready to go other than we got to get everyone on schedule?
Next week, I'm on trial in DeKalb County, but it doesn't sound like you're talking about next week anyway. There's no discovery issue on there.
Okay. Excellent. And Mr. Luemba, any discovery concerns?
No discovery.
Okay. Is any update you and Ms. Smith and I need to talk about based on what we talked about before, or are you more comfortable about things?
A little more comfortable. I'm gonna talk to Ms. Smith at the close of the calendar, and things may shift a little bit, but as of now, all discoveries.
Good. Okay. Excellent. Then if you are one of the defendants in what I'm going to call the Francis case, no pressure, you and your lawyers are free to go. We still need to work through where Ms. Harrigan is and get her lawyer here. But the rest of you, thank you for being here. And we'll find that magic, I predict, a week and 2 days. But we'll see. All right. Take care. Silas Baker is in custody, waiting on Ms. Cabrera. James Linzer. Hey, Mr. Linzer. Mr. Linzer, who's your lawyer?
Had that team.
Okay, have you spoken with her recently?
Yes.
Okay, well, we'll check on her. Calvin Ross was a plea. Jason Bates. Hey, Mr. Bates. I'm all right. How are you? Good. How are you?
Good.
You're also good. Look at that. What's happening with Mr. Bates? His final plea rights are preserved.
I am ready. I just need to, me and the state, we're talking because I don't have any contact for any of the witnesses.
Okay, as in you're ready for trial, you're ready for,
Trial.
okay, well, I don't know why we didn't do the final plea last time, but we should at least take care of that. Whatever the state's offer is, he needs to say no thanks on the record and understand the consequences of that. So we'll do that. And that'll be, I guess, where we go next. All right, so we'll get you up here in a minute, Mr. Bates. Roderick Williams. Good morning.
He's my judge. I need to speak with the state once more to see what we're doing about that.
Okay. All right, Mr. Williams, Ms. Wood will be talking with you in a little bit and we'll figure out the plan. And then we have Marcelo Silva Rodriguez. Good morning. I'm all right.
He's my judge. We are ready for trial. I am going to speak with the state and my client once more, judges.
Okay. And to be safe, because this is on an expedited path, why don't we do final plea-ish today? So whatever the offer is, if Mr. Silva Rodriguez isn't interested in it, let's just get that on the record. With the speedy demand, this will be pretty high up on the list for next week. Okay? All right. That's it. Anyone here who thought they had a case today, didn't hear it called? No?
Yes.
Hold on one sec. We'll go. You had a bunch of cases. I'm gonna circle back with you, Ms. Cabrera. Okay.
I just have one, Your Honor, Devon took a lot of the 13 and I have.
Mr. Twitchell's right there. So you're here on behalf of Mr. App?
I am. I work for Jay, and I need to speak with my client. I'm also have another appointment at the Judge Roth's courtroom at 9 o'clock. So
What's the appointment in Judge Roth's courtroom? Okay. Well, here's a trial calendar, felony trial calendar. Why don't you talk some with Mr. Twitchell? The prosecutor you're gonna be dealing with is Mr. Abadi, who is seated directly in front of you, so second row there. The two options for Mr. Twitchell today are I'm working the case out or I will be here on Monday for trial. And when I say working the case out, it could be a non-negotiated plea. I don't mean it has to be, we agree on how it's gonna play out, but either it's a plea today of some form or on Monday, Mr. Twitchell and you or Mr. Apt or someone else from his office are here ready to go with trial.
yes, sir.
Got it? Excellent. And then you, sir, are? Oh, Mr. Sinkfield. All right. Ms. Taylor was gonna try to get did she say who she was gonna have be here? Okay. Pardon me? That's the lawyer? Well, can you say that name louder? Oh, Jacoby Hudson. Okay, but we'll reach out to Mr. Hudson. Okay, thank you.
Your Honor, I'm here on the call. Mr. Johnson for Dontavious, right?
Okay, that's not who we were talking about, but I'm gonna get to you in just a second.
Okay, I'm sorry.
That's okay. All right, turning to the call. Good morning, Mr. Johnson. I understand you are not feeling well. Sorry to hear that.
That's an understatement. Thank you. Appreciate it.
Okay. So here's the update that I have. I think it's what you already know. We don't have the report back that you have requested. It is due mid-January. I don't know exactly what that means, other than it's not yet, and hopefully it's before January ends. But until you and I get that report, we can't really move forward with Mr. Wright's case. So I already excused Ms. Willingham, who is the prosecutor on the case, and let her know, because she has a specially set murder on my February calendar, that we would move Mr. Wright to the March trial calendar, assuming the results of the work that's being done indicate that we should move forward with the case. Obviously, if the results say something different, then we're on a very different path. So you and I need to get that, and we'll see what it says. And then either we'll tee this up for trial in March, or we'll need to come up with a different sequence of events. Does that work for you?
Works perfectly. Thank you.
Okay. Is Deputy Gordon back yet?
No, sir, they have a situation downstairs today. Sorry. Yeah.
Okay. Did it involve any of our inmates?
Not that I'm aware of.
Okay. All right. Got it. Okay. It's a tough day for the sheriff's team. So all I was going to offer up, Mr. Johnson, was that if Mr. Wright had been brought upstairs, he could come out so he could see you and me, but he is still down in the holding area in the building. So I'm going to let you go and heal and get well. And just know that we'll put Mr. Wright's case on the March trial calendar unless the report that is coming mid-January says something different.
Thank you, Anna, and Happy New Year.
All right, you too. Take care.
Thank you. Bye-bye.
Since the light of that announcement, I'll probably just go over to the jail and see Mr. Comer if I may be.
You may. Thank you for being here. And please reach out to Ms. Nelson if there's any hiccup with discovery. I have no reason to think there is. What I don't want to do is get this on another calendar and then you say, well, I still don't have this police report or this or that, but I think you'll get it all.
And Mr. Biden has been very responsive, so I don't anticipate we'll have any problems. So,
Good. All right. Take care. So we can't do Mr. McCrary yet because he's not up because of what happened downstairs. So, Mr. Walls, if you're available, that means we can do Mr. Gates right now.
Yes, Your Honor. Yes, Your Honor.
Great. Mr. Gates, you want to come up to the podium? And then if people need to pre-try or whatnot, go for it. Oh, Ms. Cabrera, while Mr. Gates is coming up. So,
Brandon Baker.
well, I know you and Mr. Abadi were talking, and so I don't know if you've got an update for me.
Nothing's changed from Monday.
Okay.
When we had our conference, so,
We're still heading towards trial. Okay.
and I'll still, I'm gonna go speak with him and see if there's any interest in doing something different with the state before we even get to the trial calendar.
Okay.
So I'll follow up with Mr. Abadi. The other person I know I have is Silas Baker. I just need to confirm that recommendation so that I can talk to him if he's in the back.
He isn't up yet. They had a little issue downstairs, not with Mr. Baker, but he'll come up. You think that'll be a plea?
I think so. If what we kind of talked about on Monday is the same, then I think it's great.
Okay, and you were speaking with Mr.
I think.
It might have been Mr. Sperry at the time. All right, well, Mr. Miller is a very capable replacement for,
Just like Mr. Sperry.
yeah,
So.
better hair. You also have Ms. Faria.
Yes, she's here, and I need to get the state's position on.
Well, we're about to take a plea in the case
I'll find out.
with Mr. Gates, so let's do that plea, and then we'll see what that means for Ms. Faria.
Talk to, Terrence.
And you have Ms. Harrigan, who didn't show up.
She should be here.
Oh, she is here. Okay,
I was outside.
Yeah,
okay, got it.
she's here. So I'll follow up after you finish, Luke.
We'll do talk with her, but the situation with Ms. Harrigan's case with 4 other defendants is that we cannot go forward next week. Mr. Adams, who is co-counsel on Ms. Francis's case, is not available next week. He's got to be out of the country for a funeral. And Mr. Melnick, who represents another defendant on the case, will be in trial in DeKalb. So
Going into a trial calendar again.
I got to talk with Ms. Nelson about that, probably March. But the state said, gosh, 5 defendants, probably going to take more than a week to try it. And then Mr. Adams said, we could try this case in 3 days. It was almost like, name that tune. I would be shocked if a 5-defendant case could be knocked out that quickly, but we'll see what happens.
Fair enough.
So Ms. Harrigan should stick around.
Yeah, just long enough for me to talk to her and then she'll be able to leave.
Good. All right. So when Ms. Cabrera says you can go, and I'll cross your name off the late list. Okay. And now let's do Mr. Gates. Mr. Gates, can you slide over a little bit? That way, great, your lawyer will be able to see you. I will add him and you. All right, we've got everyone we need except Ms. Rivers. Good morning.
Good morning, Judge. How are you?
I'm well. You ready to go?
Yes, I'm ready.
Excellent. This is position 19 on our trial calendar, 25 SC 003230. State versus Gates. Mr. Gates is here in court. Good morning, sir.
Morning, sir.
His lawyer, Mr. Walls, is appearing virtually. He is on leave and has taken time from his leave to take care of his client's business. So thank you, Mr. Walls. And then we have Ms. Smith for the state. Mr. Gates, before we can start this, I need to make sure you are comfortable moving forward with this setting. And by that, I simply mean your lawyer, Mr. Walls, is not standing right by your side. He's here virtually. He can see and hear everything you're doing. He can hear what I'm saying. But he is at whatever nice resort in another country he's spending his break at. Are you okay proceeding in that way?
Yes, sir.
Okay. Know this, if at any point you want to speak with him privately, you just let me know. We'll get you outside the courtroom. You can call him up, have a confidential conversation. I don't think you'll need to do that, but that's your call and not mine. So if at some point you want to confer with him, just let me know and he can drop off this, talk with you, and then we'll get you back on.
Yes, sir.
Other thing, if at any point you just got a question about what's going on, let me know and he can answer it, I can answer it, as long as it's not something you need to say confidentially, but I don't understand what that means. What are you talking about? That doesn't need to be a private conversation. Just tell me I'm not following what's happening. I'll try to explain it or Mr. Walls can explain it. Okay?
Okay.
Excellent. Ms. Smith is going to put you under oath in just a moment. After that, everything you say needs to be truthful and complete. And as I mentioned, let me know if you have any questions. All right?
Yes, sir.
All right, Ms. Smith, when you're ready.
Yes, Your Honor, before we start the plea, there is a lesser included in the 2 no process on this. Would you like for me to tell you about those?
Yes, please do. I've got Mr. Gates listed for four
Yes.
counts?
Yes,
Okay,
Your Honor.
all right.
Count 2 and count 3 will be no pros.
Those are both possession of a firearm during commission of a felony?
Yes, Your Honor.
All right, those are being, no pros means dismissed, so those are going away.
Count 4 will be reduced to the lesser included possession of a firearm by a convicted felon.
Okay, right now it's charged as use by convicted felon? Okay, so it'll be reduced to the standard 1 to 5.
Yes.
Okay, so count 4 is a felony, it's being reduced to a less serious felony. And how about count 1?
Count 1 is staying the same. Your Honor.
Staying as is. Okay, got it. Mr. Gates, do you follow all that?
Yes, sir.
Those are all good things for you that were just announced.
Okay.
Okay, all right.
All right. Mr. Gates, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can lower your hand. Can you state your true, correct, and legal name for the court?
Isaiah Cornelius Gates.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning?
No, ma'am.
How old are you and how far have you gone?
The last part, there was noise.
How old are you and how far have you gone in school?
27 years old and I got my GED.
So you're able to read, write, and understand the English language?
Yes, I am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
I have.
Do you need more time to discuss your case with your attorney?
No, I do not.
And are you satisfied with his services?
Yes, I am.
Counsel, are you satisfied that your client has a full understanding of the proceeding?
Yes,
Also, counsel, do you waive the formal reading of the indictment?
I do.
And what about any and all defects in the indictment?
Yes, I do.
Mr. Gates, do you remember being arrested on these charges?
I do.
And the state is currently unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any warrants related to these charges?
No, ma'am.
Well, there was a bench warrant. Actually, his bond was revoked, but other than that, I'm not aware of any warrants.
Right. No, thank you for flagging that, Mr. Walls. I did revoke Mr. Gates's bond because of, I think it was Clayton County. You were recently in custody somewhere. We're gonna work through that today. If you resolve your case, bond doesn't matter anymore because you don't need a bond because you've resolved your case. But I'll make sure I address that if the plea goes through.
All right.
Mr. Gates, do you understand that today you're entering into a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years probation?
Yes, I do.
Do you also understand that the court does not have to accept that recommendation and that they can sentence you on a maximum on each charge, and those sentences can run consecutively, meaning one after another?
Yes, I do.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, I do.
Do you also understand that if you're charged with another crime in the future, that this plea may be used to enhance that sentencing?
Yes, ma'am.
And are you currently on probation?
Yes, I am.
Do you understand that if you're currently on probation, your probation may be revoked based on you entering this guilty plea today?
Yes, I do.
Do you also understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, and the right to receive, possess, or transport a firearm.
Yes, ma'am.
Do you understand that by pleading guilty to this felony, you cannot use, receive, possess, or transport any firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that by entering this guilty plea, you waive any and all defenses, including any mental health defenses?
Yes, I do.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear witnesses called against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands these rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Gates, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea today?
No, ma'am.
And as to indictment 25 SC 003230, how do you plead to count 1, purchase, possession, manufacturing, distribution, or sale of marijuana?
Guilty.
How do you plead to count 4, the reduction of the lesser included possession of a firearm by a convicted felon?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Are you aware that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that this must be completed within 30 days of today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Gates. Your Honor, if this case would have gone to trial, the state would have been able to show that on March 31st, 2024, while patrolling the Peachtree Dunwoody Road, officers, let's see, hearers. And also observed a silver Honda Accord, Georgia tag, CTL 8886, traveling southbound on Peach Street, Dunwoody Road with the front passenger not in a seatbelt. At this time, the officer then conducted a traffic stop. Once he conducted the traffic stop, he saw that it was 3 occupants inside, one of those being the defendant, Mr. Isaiah Gates. Once he approached the car, he did smell a strong odor of marijuana coming from the vehicle and requested all 3 of the occupants to step outside of the car. At this time, the officer then searched the car and found a black Glock 19 found between the driver and passenger seats, and also a Glock 43 observed on the floor, rear left passenger side, next to a black backpack and a jacket. In that black backpack was 13 baggies of suspected marijuana that was confirmed through the GBI lab as 30 grams of marijuana. Also next to that black backpack was a purse that had $585 in it that belonged to another co-defendant. All parties of this group denied ownership of the firearms and the drugs, and then they were all placed under arrest. After being placed under arrest, Mr. Gates did admit that one of the guns were his. At this point, they were all arrested for the charges that we have on the calendar today. And those are the facts of the case. Regarding the negotiated plea between the state and the defense, we've agreed to a sentence of 5 years probation for count 1 and 5 years probation for count 4 for those counts to run concurrent. Regarding the special conditions of probation, the state is recommending that the defendant have no weapons, have a Fourth Amendment waiver, drug and alcohol evaluation, and to have no drugs that are not prescribed. And that's all from the state, Your Honor.
All right. Did you learn later through the investigation if the backpack and jacket or who is seated where in the car? That would seem to influence a lot of this.
Yeah, so Mr. Gates was sitting in the back seat with the bag that had the marijuana. You had another co-defendant in the passenger, and then the driver is also a co-defendant.
Was the driver Ms. Faria or was the driver Mr. Lewis?
It's for real.
Got it. So front seat passenger is Mr. Lewis, driver is Ms. Faria. You got Mr. Gates in the back seat where the Glock 43 is found, along with the backpack with the marijuana and the jacket.
Yes.
Okay, that makes sense. Thank you. We've got pretrial officer Washington on. Good morning.
Good morning, Your Honor.
How are you?
I'm well.
Great. Can you share with me what you've got in terms of criminal history for Mr. Gates?
Yes, there are 7 arrest cycles. There was a 2025 felony conviction for possession of a controlled substance and purchase, possession, or sale of marijuana out of Clayton County, and the defendant is currently on probation for that case. A 2016 felony conviction for armed robbery and an FTA from 2025, as well as a probation violation from 2025. Nothing further.
Thank you. Mr. Walls, when you're ready.
Nothing further, Your Honor. We just ask that you accept the negotiated plea, Your Honor. We do believe that the plea is appropriate under the circumstances.
Okay. Mr. Gates, it sounds like just last year picked up a case in Clayton County. Was that why he was in jail when we had court, or what? Just help me with the timeline with the Clayton County stuff. Or were those not cases matters you helped him with?
Your Honor, I did not help him with those matters, but it is my understanding the last court date he was incarcerated in Clayton County. And actually, I believe the last appearance we had, Your Honor, instructed Mr. Gates to address a probation violation in Gwinnett County, and he did that. And he was able to resolve those matters. And Mr. Gates has been accessible. He's made availed himself to the courts. And I don't perceive that my client will have any more issues if this plea is accepted and everything is ran concurrent to his current probation, Your Honor. But yes, to answer your question, he was in Clayton County. I believe your wonderful clerk was able to find that he was there.
Okay, got it. Mr. Gates, the armed robbery case, what jurisdiction was that in?
That was in Gwinnett County.
Okay. And did you go to trial or plead?
No, I pleaded.
Okay. To armed robbery or to something less?
To armed robbery.
So how long were you in custody?
I was in custody 8 years.
Okay. and you got out, so that would make it like 2024?
2023.
2023. And since then, you've had the Clayton case, and this is, I guess, older than the Clayton case. This situation is older.
Yes, it is, Your Honor.
Okay, all right. So am I understanding the facts closely enough that basically you were the guy in the back seat of the car?
Yes, sir.
So that would mean Ms. Faria is not particularly connected to whatever was in the back seat of the car. I mean, she's driving the car, but it's your stuff in the back?
Yes, sir.
Okay, you don't, I mean, if it's not, it's not. I'm just trying to understand. I got two other defendants to work through. Mr. Lewis has a bigger fish to fry in the cab now, but I need to sort out Ms. Faria's case as well.
Yes,
how did you know her?
I knew her through, she's an old friend.
Okay. How'd you know the guy in the front seat?
I met him, he's also an old friend.
Okay. All right. And these days, what are you doing? Are you working?
Yes, sir.
Doing what?
I do security at a restaurant, and on the side I do orders for deliveries, but I don't drive. I don't drive, but I drive and pick off GoPuff, Uber, DoorDash, as well as my security. But
Okay.
I'm currently about to enroll in school for industrial construction.
Great. When you say security at a restaurant, meaning like you're a guy at the door, or what is it you're doing?
The door, wherever position they put me in, they usually put me at the door, rooftop, sometimes in the kitchen.
What kind of restaurant? Like if I go to McDonald's, there's not a guy on the rooftop?
No, it's not that type of restaurant. It's a bar, lounge, club together, but it's mainly a restaurant.
All right, but it's got a club element to it.
Yes, sir.
Okay. Any kids?
No, ma'am. No, sir.
And do you stay right now by yourself? Do you have roommates, family?
I have a roommate and family.
Okay. What county is that in?
Wilson.
All right. Do you have any questions about anything we've been talking about?
Not that we're going to talk about, no.
You have questions about other things?
Yes. As an instructor, I turned myself in for the last time we spoke. I was approved for the DRC in Fulton County, and I've been waiting orientation for that. And I was released on December 19th, and I've been waiting for orientation for seeking.
For the day reporting center?
Yes, sir.
Issue on Saturday.
Okay.
His case, his probation was initially in Gwinnett, where his initial case started, and he's waiting for us to transfer him to us.
Okay, but if now Mr. Gates lives in Fulton and with this case,
Yeah, so.
MADRC should work out?
Atlanta, officer, so I'm going to give it to his chief and see if they can go ahead and pull his case off.
Would it make things easier or more complicated if I added as a special condition of probation that he do the MADRC?
It's already a condition from his revocation in November that he had written it.
Okay, and that's where you went when we had court before. I think it's what Mr. Walls was referring to. I said, look, I think there's a warrant for it. You got something up in Gwinnett. You went up there and dealt with it, got revoked, and they added the DRC.
Yes, sir.
Okay, so I should not add it as a condition here? Okay, all right. Will Mr. Gates be getting a new probation officer because of this case?
Not necessarily a new one, he's already has his new one since he's unofficially under us.
Okay,
So no, it won't change.
so who will help Mr. Gates plug in with the DRC? This officer?
It should be his new officer with us.
And who is that?
Officer
Alan?
Yes, Judge.
Okay, have you connected with an Officer Allen yet?
I met with Officer Allen, I believe, on the 5th. He just came. Today's the 7th. He came.
It is. Good. All right, so that's your answer, is that you work with Officer Allen, and that's a he? He will help you figure out how to get started with the day reporting center.
Yes, sir.
Okay. Well, Mr. Gates, do you have other questions?
No, no.
That was it. All right. I find there's a factual basis for your plea. You're sort of geographically guilty in this case. You were sitting where all the stuff was. And it sounds like you claimed the gun. You're a little less clear about the backpack, but I think a jury could find you guilty based on the information that Ms. Smith shared with me. I also find that your plea is knowing, meaning you've understood what we talked about.
Yes,
You
sir.
agree with that?
Yes, sir.
And it's voluntary, meaning no one's forcing you to enter this plea. You agree with that?
Yes, sir.
All right, then I'll accept your plea. Mr. Walls, can someone in my office electronically sign your name to the indictment that'll show the guilty plea to count 1 and count 4 reduced?
Certainly, Your Honor.
All right, and Ms. Smith, can we sign for you?
Yes, sir.
Mr. Gates, is it okay if we electronically sign your name to the indictment indicating your plea?
Yes, sir, but, one question, will I receive it as well, or?
So, Mr. Walls will be able to get you all the paperwork. The indictment with those signatures, will get e-filed, meaning it'll get put in the docket, and Mr. Walls will get notice of that. So you just check with him and he can get you a copy of that. There'll also be a sentence. It's called a final disposition. That's what I sign.
Okay.
And that's what's going to say what your sentence is and all the terms of that. Mr. Walls will get a copy of that as well, and he can get that to you.
All right.
Okay? You shouldn't have any issues now with the fact that I revoked your bond. I did that because you were in custody in Clayton, and that said to me, there's something going on. But you don't need to worry about bond now that I've accepted your plea, so that shouldn't be an issue. And I will follow the negotiated plea in this case. So your sentences to count 1 is 5 years. Count 2 and 3 are both dismissed. Count 4 has been reduced to possession of a firearm by a convicted felon. And what's the statute for that?
1611-131.
1611-131. There it is, 131. That'll be 5 years as well. Both those will be probated and they'll run concurrently with each other. So it's a total sentence of 5 years of probation. And the main condition that you had asked for, Ms. Smith, was drug and alcohol evaluation and treatment. But if Mr. Gates is going to be doing the day reporting center, that's going to more than cover it because he's going to get screens all the time. He's going to be getting good treatment, job training, et cetera. All I'm going to do is have as the special condition of your probation that you successfully complete the day reporting center. So if for some reason that didn't go well, that's a problem in Gwinnett, but it's a problem here as well. Okay.
Yes,
I think that's it. Deputy Gordon, someone wants to see you. We're going to send Deputy Jones instead. So that'll be it. You'll work with Officer Allen to figure out how to get started with Day Reporting Center. And I hope someone told you up front, it's pretty time consuming. You'll be there every day, not for Saturday and Sunday, but that's why it's called the Day Reporting Center.
Yes, sir.
As you move through it, it'll take up less and less of your time, so it'll be easier to have a job during the day. If your security work is in the evenings and the weekends, it's not going to be a conflict. But just know that your attendance at the Day Reporting Center is part of your probation, okay?
Yes, sir.
Any questions?
No, sir.
All right. Do you need any information, Ms. Simpson, from Mr. Gates?
I just need, Mr. Gates' name. I already have his address because we had spoke previously.
Great.
So, I just need to give him his date so that his office can go over his conditions.
Okay. So Ms. Simpson will meet with you right outside, giving you your reporting information, all that kind of stuff. You're going to have the same officer for all your cases. Are you on probation out of Clayton as well, or was that not a?
They all transferred over to Fulton.
Okay, right. So one officer, all 3 cases, you just got a lot of riding on it. So hopefully things go smoothly. Ms. Smith, anything else from the state?
No, Your Honor.
Mr. Walls, anything more before we release you back to wherever you are?
No, Your Honor, I just wanted to wish you a happy new year. I want to wish Madam ADA Smith a happy new year. And I would like to wish Miss Nelson a happy new year. Thank you guys so much for accommodating me.
You bet. You go back to doing what you're doing. Thank you for being flexible and being here for your client. We'll see you around. Good luck, Mr. Gates. Just make sure you talk with Ms. Simpson and then you're good to go.
All right, thank you. Have a nice day.
You too.
Your Honor, can I make 2 announcements?
Yes, announcements time.
Regarding the case with 18, this Ms. Favera's case with Taylor Farah.
Yeah.
Because Mr. Gay was taking responsibility of the marijuana that was in the car, and the case will be no cost in this case from the state.
For Ms. Faria only.
No, I'm about to go with it.
Oh, okay. All right.
But that's just for Ms. Faria. Her case will be dismissed. And then for position number 2, the disease Lewis stated also about the law process case because of the current charge that Mr. Lewis has, I believe, in DeKalb County. And we believe that's the best when it comes to the judicial efficiency of this case. And also because Mr. Gates has taken responsibility for that marijuana, those charges fall off for
Mr. Lewis also.
Okay, so Ms. Faria, thank you for that. Ms. Smith has just announced that in light of what the discussion Mr. Gates and I just had, the state's dismissing your charges. So Ms. Cabrera may want to talk to you a little bit before you go, but you will not need to come back here for that case, okay? All right, you're welcome.
Mr. Baker will be a plea whenever you're out.
Great. We will,
Stop right.
Silas Baker, we will do that.
And he's the one that's in the wheelchair.
Okay, we need to do McCrary first, but I want to pick up a few other announcements. So Silas Baker is 28, moves over to here.
Yeah, we have to take our time with him. He understands, but still have the time.
Okay. Did anyone show up who wasn't here at the start of the day when I was calling the calendar? Sir, you are?
I got you. Okay.
Excellent. All right. You are here. Your case, Ms. Wood, what are we maybe doing with Mr. Burden today?
Hold for my announcement.
Okay. Got it. Mr. Burden, Ms. Wood is going to continue to negotiate on your behalf to see what she can do with the state. So you should sit tight. If you need to head out of the courtroom from time to time, that's fine. But don't leave the building until either Ms. Wood or I says, we're not doing something today. So you know, if we don't resolve your case today, then the trial calendar starts next Monday. So you need to be here Monday, ready to go to trial. All right? Yes, ma'am.
Morning, Judge. I'm here for James Windsor, J3, filling for Heather Valentine.
All right, let me find that. Number 29, Mr. Linzer. Mr. Linzer is right there. Have you had a chance to speak with Ms. Smith?
I haven't, so I need to probably the case, change and.
Yeah, so my understanding, if this is the correct case, this was re-indicted to add a piece about a check. Don't hold me to this, but either a check that bounced or a check that wasn't written. There's a, I don't want to overstate it, but a theft or a non-payment component that resulted then in the alleged terroristic threat. So it's not like they added something completely unrelated. It was sort of part of the storyline, but it was a recent indictment. And so one thing you and Ms. Smith need to talk about is waiving arraignment or how we work through that. But it is on a trial calendar. So if we aren't sorting it out today, then Monday is when we would be moving forward with the trial. Assuming you and Mr. Linzer are comfortable moving forward with the re-indictment. Because if the state's insisting on going forward with the re-indictment, we need to either do a waiver of arraignment. It's no new discovery or anything like that. But it's a slightly funky posture.
Yes, Judge. So I just need to speak with the state because, like I said, Heather's been speaking with the state, so I just kind of need to.
Okay.
Figure out what they would keep holding on that.
Are you fully deputized by Ms. Valentine to work the case out, or does she need to be here to make things happen?
I could actually approach on that, if that's okay.
Sure.
It's kind of situation involving our office.
Okay.
So I don't know if you want that now or.
In a moment.
Okay.
All right, so we'll talk about that. So you're here for Mr. Linzer. That's good for Mr. Linzer. Anyone else? Mr. Sinkfield? No, I know you're here. So no bench warrant for you. We reached out to Mr. Hudson. I just don't know what the answer is about Mr. Hudson. Unless you've got an update. No. You're trying to contact Ms. Taylor? Okay, sounds good. Just make sure you come back. All right, yes, sir.
Did you call a calendar for Mr. Ricky Pierce?
I did call the calendar for Ricky Pierce. He's missed. I'm sorry, say that again?
He's going to be in court this morning.
So he's in the building. I'm not sure if he's going to come up because we're not able to move forward with his case. He's filed an appeal. And as long as that appeal is pending, I don't have authority. Authority sounds kind of strange, but if someone appeals something, then that case is with the higher court until the higher court says we're dismissing it or we're granting it or doing whatever. Well, you're free. You can do whatever you want, Mr. I'm not making you stay here. But I don't know how much interacting I'll be doing with Mr. Pierce today because that appeal is still there. Okay, you bet. All right. And then, sir, did you?
brother.
No, that's fine. I'm sorry. The gentleman you just walked past had stood up as well.
Okay,
You too. Thanks for being here.
all right.
Yeah, great.
Mr. Daniels, the man from, now are you in Texas?
Yeah, I'm in Texas now.
Okay.
So I did speak with, Lacey Woods of the Public Defender Office, but she was supposed to, is she?
She's here.
Okay, yeah.
Red hair.
And, so I was supposed to show up, so I'm here.
You were supposed to show up. That's good that you're here. Have you and Mr. Daniel had a chance to talk?
We did speak on the phone. I do need to do an actual application for them. I will do that.
Okay, sure. We'll find out. So you should stick around. And if you are eligible for appointed counsel, that's your person. If you're not eligible, then we're back to where you had been before. I know you had retained, I think at one point you had Mr. Smith. I know you had Mr. Manciagli. So you're going to need to be explaining to Ms. Wood what's changed financially. But she'll talk with you about that. We have a plea we have to take first. And then maybe we'll pause so that lawyers can pre-try things. Okay? Anyone else? Ma'am?
Is Whitney Sharma coming up today?
He is. I've been told he's entering a plea today.
Thank you.
We'll see what happens.
Yes, sir.
All right. Hello, sir.
Morning, Judge. Tim Cook.
Hey, Mr. Cook.
How are you? Thanks for holding my report.
Not a problem. And you have Mr. Pendleton.
That's right.
And you have a prosecutor right there.
Hello.
Yeah, we've traded up. So you should talk because if we're not resolving Mr. Pendleton today, then we've got a trial calendar on Monday. All right?
We're going to see if we have an offer.
Excellent. All right. Well, you guys talk and then we'll confer. All right. You're welcome to use the jury room if that's where you want to go. Hi.
Can I approach the prosecutor quickly?
You sure may. So the person who's not Ms. Valentine, I didn't get your last name. Green. All right. I'll remember that. Ms. Green, why don't you and Ms. Smith and I talk real briefly? And then we're going to bring Mr. McCrary out and do that plea. But I just want to make sure I'm in the loop about what's cooking with Team Valentine. Did you get the code section 131? I didn't write you back.
That's okay, I heard it.
You heard it.
What she said.
Yeah.
I was looking at another one, one has a subsection B versus number. And so I just want to make sure.
We're going to talk for 1 second about something. I don't know. Can you come around?
Yes.
I'll get you the subsection.
You said it didn't sound like, yes, we're going to the wrong car. You know, it's a certain size. It's a really size. We can see there's something. I could just say, well, my daughter, my couple, we listen to like I'm standing, but I got sleeves and it's a couple that was perfect. I would look at that thing, this and I'm like, it's my thing. It's not yours. It's not yours. Get it out of your room. Take it out of your room. What the thing you're not. And so I said, I gotta come back over there with this thing. Right. So I'll just pressure you to come over. I said, why did you call? Yeah, you said that. No, yeah, get it on. Don't I said, no. It's not a question. I'm your radar. I'm so proud. Also.
Yeah. It's a homeless thing.
So I was a big.
Things got probation holds. So like, did it? I don't think they know. No. So that's why I'm like, we gotta get this going. Yeah.
One of the co-defendants, so the only one there, so that's one of them with the A. So he's the one dismissed, she during this investigation. I guess it's.
That's fine, I'm gonna talk, yeah, so I'm gonna talk to her. I'll just February. Where she posted.
Happy New Year, Adam.
Happy New Year, how are you?
How many weeks is your February?
You taking a break?
Everybody said that they, taking that, when we go down. That's what I said, mine was 2 weeks. March, did you say? So.
Good morning, Adam. How are you?
I'm gonna tell you, Happy New Year.
Oh.
Good, how are you?
He's like my favorite.
Yes.
Floating around.
Lying on your life.
No, I don't.
Anybody see the clerk on the phone? Oh.
Are you doing the McCrary plea? Okay.
Is it fun?
Let's see, where does this stuff plug in? There is, check under. Is that open? There's like the cat, because this cord, this is a power cord, so it's going into something. See if I tickle that cord, do you see? Let's get Deputy Gordon to look under here.
I got it.
Oh, even better.
I don't know, he has a vest on, I don't know if I can do that.
He's wearing his formals today too. We're seeing if there's a plug.
Yeah, it's got a power. It's your power.
She just wants to plug in her laptop.
I can't get in touch with, is it Dante Hudson that's supposed to go? I didn't know what Hudson.
No, Jacoby Hudson.
Oh, Chicago.
Yeah,
I didn't hear there's.
Yeah.
But I tried to call.
no, not Dante.
No, I didn't try to.
Okay, yeah, Jacoby.
I tried to call.
Okay. Well, if you're able to reach him and he says, I'm gonna be here. Yeah.
I guess somebody's still on the movie.
Did we find a plug? Oh, excellent. Good work. And is this thing still plugged in?
No, it's only sharing one cord.
Oh, because, yeah, if that's not in, then Ms. Rivers can't see. So, are there multiple sockets? We need to have two.
Yeah.
Oh. Well, let's plug that baby back in, please. Well, this investigator unplugged it. It's, need you to take him into custody.
Wait for it.
Hey, well. Back in. There you go.
Thank you, sir. I had to add it back. Momentary chaos. Is it monitor on now? What does it show on that monitor? It's loading? Okay. Sorry, Ms. Wood, a little
All good.
hiccup.
Judge, I don't know if I said it already, but this is not negotiated.
Non-negotiated.
Yes.
Got it. What's on the screen now?
It's the invitation to join the Zoom.
Great. I think I can do that from here.
We're back up now.
There's nothing going through. Is there a camera?
It says preferred camera is not working. Please reconnect or restart camera. I can see my box, but it's blank.
Rats. We shouldn't have unplugged it. Mr. Sinkfield, Mr. Hudson's going to be here in about 25 minutes, okay?
No, that's
So what I'm going to need you to do, Miss Smith, is, oh, wait, something just happened.
It says
All right, let me press a button and see if this helps. No, that didn't do it. Whoop. Do you have a button there that?
Yeah, so I'm pushing start my video now.
All right, we'll get IT here, and just speak loudly, and Ms. Rivers will have to go based on voice.
Okay.
Yes, I can hear her well.
Okay, great, then we'll get rolling. Are you still ready for Mr. McCrary? We left you hanging up there for a while.
I'm just gonna farm out Ms. Rios for a minute.
Okay, we're ready for Mr. McCrary. Hey, Mr. McCrary, I'm sorry we kept you waiting. We had a technical issue here with a piece of equipment. But we're ready to go. I appreciate you being patient.
Thank you.
All right, let me,
Wanna set that in?
it's your piece of paper. All right, Ms. Rivers, are you good to go?
Yes, I'm ready.
Okay, this is 25 SC 005644, State versus Charles McCrary, who's here in court. Good morning. He's here with Ms. Wood, his lawyer. We have Ms. Smith, the prosecutor, seated to my left. And Mr. McCrary, Ms. Wood tells me that you're ready to enter a plea. Is that right?
Yes, ma'am.
Okay.
Yes, sir. I'm sorry.
That's okay. That's okay. It's what we call a non-negotiated plea. Ms. Smith is going to be recommending one sentence. I don't know what it is, but we're going to hear about it in a minute. And then Ms. Wood is going to recommend something different. And then I'm going to decide what we're going to do with this. And we'll go from there. Ms. Smith is going to ask you a bunch of questions about you and your case and your rights. You need to answer those questions as best you can. If at any point someone asks you something that you don't understand or says something, they're using some fancy legal word or something, let me know and we'll try to explain it in a different way, okay?
Yes, sir. Yes.
Excellent. All right, when you're ready, Ms. Smith.
Okay. Mr. McCrary, may you raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hand. Can you state your true, correct, and legal name for the court?
Charles Gerald McQuarrie Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, I'm not.
And is there any medication that you would normally take that you haven't been given this morning?
No, I haven't.
How old are you and how far have you gone in school?
I'm 22. I'm 10th grade.
Are you able to read, write, and understand the English language?
Yes, I am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Okay.
Do you understand that?
Yes, I do. Yes, I'm sorry.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, I have.
Do you need more time to discuss your case with your attorney?
You're good to go. And if you just have any questions, you'll ask me, or do you need more time to talk to me?
No, I feel I'm ready.
Are you satisfied with her services?
I definitely am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
And do you waive the formal reading and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. McQuarrie, do you remember being arrested on these charges?
I do.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not.
Do you understand, Mr. McQuarrie, that this is a non-negotiated or blind plea and that the state will recommend a sentence to the court?
I do.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence that's recommended by the state, up to the maximum sentence on each charge?
Can you just repeat the question, Ms. Smith?
Yes, of course.
That's what we talked about in the back, but I'm allowed to repeat it, so just listen closely, okay?
Okay.
Do you understand that by entering this plea, the court can impose any sentence authorized by law that's higher than the sentence we recommend as the state or higher than the sentence that your attorney recommends? And also that the court can recommend a sentence that has the maximum sentence for that charge?
We were talking about the back, and if the judge were to do that, we can withdraw it today.
Okay, I do.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I do.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, I do.
Do you understand that if you're charged with another crime in the future, that this plea may be used to enhance that sentencing?
I do.
Are you currently on probation?
Yes, I am.
Do you understand that since you're currently on probation, your probation may be revoked based on you entering this guilty plea today?
Yes, I do.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
I do.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense?
Yes, I do.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, I do.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, I do.
Counsel, are you satisfied your client understands these rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. McQuarrie, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea?
No, they haven't.
As to indictment number 25 SC 005644, how do you plead to count 1, aggravated assault, and count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies?
I plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
She is not.
Can you repeat the question?
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
I'm sorry. Do you understand what?
Yes, yes, yes.
Okay.
I'm sorry.
You're okay. You're okay.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, I do.
Do you also understand that you have to complete this within 30 days of today?
I do.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, I do.
Okay, thank you, Mr. McQuarrie. Your Honor, if this case were to go to trial, the state would be able to prove that on August 22nd, 2025, officers with the Atlanta Police Department responded to a person stabbed call at 294 Eugenia, that's Eugenia Street in Fulton County. Upon arrival, officers found Mr. James Marcelli, Marinelli, on the ground at the BP gas station with a large stab wound in the chest, sitting or lying in a pool of blood around him. Mr. Marcelli was able to tell officers that he was in a verbal altercation with the man later identified as Mr. Charles McQuarrie. The argument escalated when Mr. McQuarrie stabbed him. Mr. Marcelli was able to run away and get to a BP gas station for safety. Officers canvassed the area following the blood trail to where the stabbing took place, located the knife used, and Mr. McQuarrie walked up to the officers covered in blood and admitted to stabbing Mr. Marcelli. Mr. McQuarrie was arrested and transported to the Fulton County Jail and charged accordingly. And those are the facts of the case. Regarding the state's recommendation for sentencing in this case, the state is recommending 10 years to serve 5, breaking that up with the counts. For count 1, we're asking for 5 years to serve, and for count 2, 10 years probation, for a total of 10 years served 5. Regarding the special conditions of probation, we're asking for an anger management course, a mental evaluation, alcohol and drug evaluation, treatment if necessary, for there to be no contact with the victim, to stay away from the incident location, and for the defendant to be gainfully employed. The state understands that this is a non-negotiated plea. However, this offer recommendation comes from a look at the defendant's history, a violent history of past convictions, the seriousness of the crime here. Someone was stabbed. It was a deep wound and they were stabbed in the chest. Anything could have happened. And also this defendant committed this crime while being on probation for interference of governmental property and willful obstruction. Because of that, we feel that there's a high likelihood of the defendant to reoffend. And to my understanding, the defendant has a couple of cases open also that has not been resolved. So because of all of that and totality of the circumstances, the state will be recommending or asking for a 10 serve 5 sentence. And that's all from the state, Your Honor.
Has your office had contact with Mr. Marinelli?
No, Your Honor, this victim, we've reached out to get the victim located, but he's displaced. He's homeless. We're not able to find him or any good contact information for him.
Got it. Okay. Before I turn to Ms. Wood, Ms. Washington, do you have criminal history information on Mr. McQuarrie?
Yes, I do. There are 9 arrest cycles, a 2023 felony conviction for interference with government property out of Glenn County, and he is currently on probation for that case. An additional 2023 felony conviction for willful obstruction in Glenn County, also on probation for that case. 2023 felony conviction for a CWAG offenses in Glenn County, and the defendant is also on probation for that case. There was a 2023 misdemeanor conviction for simple battery and criminal trespass out of Clayton County. There is a hold out of Glenn County for a probation violation. The warrant date was from September of last year, and nothing further.
Thank you so much. Ms. Wood.
Thank you, Judge.
Come on, Ms. Wood, let's do it.
Your Honor, so Mr. McQuarrie has been in custody since August 22nd of last year. He came on my radar pretty soon after this case was indicted and assigned to me. So my team, we began working with him very closely. He's worked with Ms. Ross and Ms. Hammonds, and he's also worked with the team at Grady through Emory's program there, Judge. He does have some pretty severe mental health issues. I do believe that this whole incident stems from the mental health issues and being off of medication and self-medicating, Judge. So as Ms. Smith said, it was a homeless encampment. Mr. McQuarrie's position is that he had been living with his sister at the time. I've actually spoken to her. She's in the area. She allows him to live with her when he's able to be on his medication and be a functioning member of society. But unfortunately, it hit a roadblock and he was off of his medication. And so he had went to this homeless encampment to find a place to stay. There was an argument. Mr. McCrary was actually hit with a rock. So he does have a position. If this case went to trial, we would be raising self-defense. He actually stayed on the scene, as you heard, and was cooperative. So I do want the court to take that into consideration. Ms. Hammonds, my investigator, was also not able to find the victim in this case. Therefore, Mr. McCrary, after much discussion, wanted to go ahead and just accept responsibility and move forward with his life. He does have those 2 probation holds. Our request of the court is on count 1, we're just asking for 5 years to serve the 139 days that he's been in, the balance probated, and then I'm asking for a suspended sentence on count 2 of 5 years. I'm sure Ms. Simpson will share, but he does have significant time left in those other 2 probations. Hold on just a second. Judge, he's 22. He does have a 10th grade education. He tells me he's got his GED. He last worked at McDonald's. And so that's our request, and Mr. McCurry is asking to address the court.
Okay. Mr. McCrary, I'll hear from you in just a second. Got a couple questions. I heard hold out of Clayton County. I heard hold out of Glynn County. The Glynn one makes sense. They probably want to chat with him for his 3 open cases after this. Is there also a Clayton hold?
Yes.
And what's that for?
Similar situation.
He's on probation out of Clayton also?
Yes.
This case is a violation of the.
What's the Clayton? Oh, the simple battery?
No, this case here is a violation of the.
Right, but what is his, I didn't hear about a Clayton I heard about 3 convictions from Glenn. I'm trying to figure out how he's on probation in Clayton.
Was aggravated child molestation.
Oh, that's not a Glynn County case.
No, Judge, the Glenn County is child molestation. And
Okay.
the second one is condoning parents.
Okay, so there's a Clayton conviction mixed up in there with the Glynn stuff as well. Okay, got it. Mr. McCrary, my question for you, are you taking any medication right now?
Yes, I'm taking mental health medication.
Okay, and what does it help you with?
My Prozac helps my depression. My Zyprexa helps with my anxiety and mood swings. My Depakote, I think, helps with that too. I think it's mood swings, and my Trazodone helps with schizophrenia and paranoia.
Okay, so you're taking all 4 of those things?
Every day.
Every day? Do you take them in the morning or at night?
I take the Prozac and the Depakote in the morning, and then Zyprexa in the Depakote and the Trazodone at night.
Okay. Did you take the ones in the morning this morning?
Yes, I did.
Great. When you take that medication, does it help you better understand what's happening, or do you get kind of woozy or confused or fuzzy?
No, it helps me better understand, and it helps me concentrate and all that. So
got it. Do you feel like you've understood what we've been talking about here?
I definitely have.
Great. Then it's your turn. What do you want to tell me?
Judge McBurney, I know that I have made some past mistakes in my life. I know this not everybody's perfect, but I've been in jail since I was 17. But I feel like this time, if you was to give me what I'm asking for, what we're asking for, this time I have a plan. I have a plan to get right into it's a support system to get me right and to do the things that I need to do to get myself where I need to be. When I got out of Clayton County last year, I was homeless. I got out being homeless. I could stay with my sister, but I really couldn't at the same time. So I had to find my own ways. You know what I'm saying? I'm not really from Atlanta. You know what I'm saying? I've been in Georgia since I was 2, but I was in DFAX when I was younger. So I never really had a chance to be free and thrive. Yes, I have an anger issue as I am in health. And yes, that night I do regret some things that I did. but at the same time, that night was duly me self-defending myself. It was I have no beef or no pressure with the victim. I have no issue with him. It was just that night I had got into an argument with my sister. I just needed to take a break. I went to the one place where I thought where I would be okay. You know what I'm saying? And I went to the camp. So, but that day, I guess the victim wasn't feeling right. I wasn't feeling right. We got into a verbal altercation. And
did you have the knife on you already, or how did the knife get into the picture?
Okay, so I'm a felon. I'm a convicted felon. Okay, so that means that I can't hold a gun.
Got it. So if you're going to carry protection, it needs to be a knife or an axe or a bow and arrow, but not a gun.
No, I felt like, cause I'm always on the go, trying to find me a job, trying to find me a place to stay. And Atlanta is known for being very dangerous. So I was like, let me just hold something in case something like somebody wants to rob me, because I had an iPhone, a 10R. I had me newest gadgets that not a lot of the homeless people had, or not a lot of people had.
Got it. So you had a knife just so you could stay safe.
Just to stay safe. It wasn't too like, oh, I'm just gonna go out and stab and spree, or no, he's not gonna do that.
No.
So I was just like, let me just have something on me to carry.
When you are not able to stay at your sister's house, how do you get the medicine that you need to stay safe?
I have a duffel bag that was on me at all times with my medication in there. I had
But how do you renew it? I appreciate you could carry it around. When you run out of the Depakote, how do you get more if you are not living somewhere?
I was going to Grady, and I was going to where was that place about beside Gateway, right behind HCD.
Mercy Care?
Mercy Care, yeah.
Okay.
It was
all right, so you had places to go to get medicine, and they'd help you out.
They did.
Okay.
I was definitely being responsible at the same time. So I was definitely I just want you to know that.
Okay, well, I appreciate that, and I'm glad that you are looking forward and that you got a plan moving forward. I think there are probably going to be a few obstacles before you're really able to do it, because you got to go to Glenn and you got to go to Clayton. But there will be a point where you're able to put that behind you and move forward in the way that you want to, and I think that's great, as long as you do it in conjunction with taking care of yourself, which means taking the medication. Because it sounds like when you're off that medication, it's not safe for you, and it's not safe for the folks around you. So I hope you keep doing that.
Your Honor, I was taking my medication on the outside. I did. I was definitely taking my medication.
Okay.
But just because I was taking my medication doesn't mean that you can't get into arguments or get a little angry.
People who don't need medication who get angry all the time. We have cases with shootings and stabbings, and there's not a mental health component to it, but there was I got real mad, and what I had at hand, instead of a beer bottle, was a gun. And so instead of hitting someone with a beer bottle, you shoot them, and then.
I wasn't thinking it was just that. I think because really, the victim was angry in the first place. I was really trying not to get into no arguments, no altercation. I guess he really just felt angry at the time and wanted to hit me upside the head with a rock and and that's what got me into defending myself.
Okay.
You see what I'm saying?
I do see what you're saying. Was there more you wanted to share?
No, really, Judge. I just wanted you to know that I'm ready for a change. You know what I'm saying?
Okay. I bet you are. I mean, you telling me I've been basically in jail since 17, that's heavy. I mean, these are good years of your life, and you're stuck, and you want to be out there and doing things that are better for you and the people you care about. So, well, Mr. McCrary, I find that there's a factual basis for your plea. So I appreciate that there's a self-defense component to it. But a jury could also decide that There were other ways to handle getting hit with a rock than stabbing someone in the chest. I don't know what the jury's going to do because you're not running that risk, which is a good idea. You could say, let's go to trial, and the jury could say, woo, this is scary, and find you guilty of all sorts of stuff. But instead, you're entering a plea. And I find there's a basis for that plea. I also find that your plea is voluntary, meaning no one's forcing you to do this. You've decided after talking with Ms. Wood and thinking about it, this is how you want to move forward because you got to get down to Glenn, you got to get to Clayton before you can do any of your plans. I also find that your plea is knowing, which means you've understood after you had a chance to talk with Ms. Wood about things, and maybe we posed the question in a different way, but after we got through all of it, I find that you've understood the things we've been talking about. Do you feel like you have?
I have.
Good. All right. Ms. Wood, can someone in my office sign the indictment on your behalf?
Yes, Judge.
And Ms. Smith?
Yes, Judge.
Mr. McCrary, is it okay if I have someone who works with me electronically sign your name to the indictment indicating that it's a guilty plea?
Yes, I do.
Good, we're gonna do that. So Mr. McCrary, I gotta figure out how we can move you on towards Glenn County and Clayton County, because those are the next spots you gotta go to regardless of what I do here. And I appreciate the state's recommendation. This stab wound, my guess is if it had been an inch or so in a different direction, we wouldn't have Mr. Marinelli anymore. He would have bled out on the spot, but it wasn't. That's not what happened, which is good for him. It's good for you, but it still was a pretty serious situation. And so what I'm going to do, and hear me out, and then you and Ms. Wood can talk about it, because as she told you, you have the ability to say no thank you right now if you'd rather go to trial. But of course, going to trial means you're not going to Glenn County, you're not going to Clayton County yet. You'll be stuck here until we can work through your trial, and then you're still going to have to go to Glenn and Clayton. I'm trying to get you in that direction sooner. I think a reasonable sentence, given what I know about this case and what you've told me about it, and given your criminal history, which I can't ignore, is that for count one, which is aggravated assault, you serve 1 year, and for count two, you have 5 years probation, which comes immediately after that. So it's a total sentence of 6 years to serve 1 year with a balance on probation. And of course, you get credit for all the time you've been in. So you've already done about half of that. And if you decide you want to go forward with this, as soon as I sign that sentence, then we can get you to Clayton and get you to Glenn, and they're going to do whatever they're going to do with your situation. So you'll be able to start moving forward. It will be a special condition of your probation that you have no contact with Mr. Marinelli. That's easy. He don't want to see you, you don't want to see him. Number two, you'll need to take any medication that a doctor's prescribed you. So if they've prescribed those 4 things, it's part of your probation that you take those 4 medications. I will ask that a probation officer who works with folks who are taking mental health medication and getting counseling work with you. So it's someone particularly attuned to your situation. Ms. Smith, did you have anything else? I know you had mentioned treatment, but Mr. McCrary's getting treatment. So I think we've got that covered.
Okay, nothing else.
All right, Ms. Wood, anything else?
No, Judge, thank you.
So, Mr. McCrary, no one's going back on their word. The sentence I gave you is a little bit higher than what your lawyer asked for. It's a bit lower than what the state asked for, but it's more than what you asked for. And so, if you want to say no, thank you, I'd rather stay where I am down at Union City in the South Annex, wait for a trial, and after the trial, then go to Glenn and Clayton. That's your right. You also could decide, I would have liked a little less, but this is not a bad situation. I'm going to take it. I'm ready to head off to Clayton and Glenn. But I need you and Ms. Wood to talk about that. She can give you some pros and cons of that. And then I'm going to have you come back out here and let me know what you want to do. But before I have you go back and talk with Ms. Wood, do you have any questions for me about what I just said?
So 6 to 1.
You got it.
Am I had to go back to Union City and come back to another court date, or it's gonna be?
No, we're done. I mean, you would physically probably go back to Union City today. I don't
No, I'm talking
know.
about like, is my court date's gonna be
We
continued?
don't have any more court. When I sign, if you say, yes, that's what I want to do, I will today sign something called final disposition. That's your sentence. That will get sent out, and then the two holds, Clayton and Glenn, can be acted on. And so I don't know where you'll go first. I don't control that, but you would likely in the next few days go to Clayton or Glenn. I just don't know which one would go first.
Okay, and one last question. So I'm gonna have to go down the road.
Not necessarily, because you got to go to Clayton and Glenn first. And they may take a little while to work through those things. That whole time, your clock is running.
Okay, I can take it.
You want to talk with Ms. Wood, or are you good to go?
I can take it.
Mr. McCrary, I hope that, let's fast forward 18 months. You are out and you are pursuing your dream. Keep taking those medications, and hopefully things will go for you, okay?
Okay.
All right.
Yeah.
How did, oh, she went back there. Okay. Yes, sir. You want to do,
No, I'll write him down.
oh, if we do someone on the outside?
Yeah, yes.
Okay, great. I need to handle things that are not in custody for a little bit, because they need to get Mr. McCrary is a special project for them, to get him going. We see a lot of people standing up. Ms. Cabrera, oh, you want to do Silas Baker?
Yeah.
Okay.
And then once we can get done with him, I have to go to Gwinnett because they're stalking me now.
Okay. Ms. Green?
So, Mr. Linder, given the circumstances, he hasn't been informed properly, so we are going to ask for a continuance.
Okay.
From the situation, and not be called for trial on Monday. That is up to you, of course, and whatever you.
No, I think given what you shared with me, that makes sense. What I would like to do today is either arraign Mr. Linzer or get you to fill out a waiver of arraignment, since we've got that new indictment. That way, there are no issues when we can get Mr. Linzer in here. And it may not be a trial. I'm not saying you got to have a trial, but I think he's entitled to get to know you and for you to get to know the facts of the case so that you can meaningfully counsel him of, hey, this state's recommendation is pretty decent, or it's crazy, let's fight it. But he needs that opportunity to work with you. And Mr. Linzer, I'm not putting you on the spot with this question, but is your current intention to continue to work with Ms. Green on this?
Yeah.
Okay, she's explained to you the dynamic. The one thing I do want us to do, though, is either waive arraignment or formally arraign, so we check that box, and that way this can remain on a trial calendar, not this trial calendar, but whichever one we put it on next.
Yeah, we can go ahead and fill out a waiver arraignment today, Judge.
Great.
Or my office can file one for you.
Well, we've got one right there. Ms. Simpson may be able to read upside down. One of them is a waiver of arraignment. And does that, if you'll take a look at that, Ms. Green, does that have a spot where you can put your information on it? Or you may need to do an entry of appearance so that we're not sending things to Ms. Valentine. But I think that may have that on there.
It does, yes, Judge.
All right, if you and Mr. Linzer would fill that out, when you're done, if you get it to one of the deputies, the two of you can go.
Absolutely. Thank you so much, Judge.
All right.
Okay.
Let me just write that down, and then Ms. McGillicuddy, I will hear from you and Mr. Cook.
A reminder, all cell phones should be put up. If you need to step out, feel free to do so.
All right, yes,
May we approach this briefly?
you may. We should go just around outside.
The final plea for Bates. Okay.
Anything. I can move it. I'm like. You need no. Yeah. Right, because I didn't fit with this book. I didn't just know. And bird, it's gonna be right now. Yeah. Yeah, what number is on right now?
I think it's just flipping around.
Alright.
Okay. I'm in.
I'm not very good about yours. You're supposed to do it a little longer,
Thank you. Okay. Thank you. Court comes to order.
Thank you.
That concludes my business. Do we need to put it on the record or?
Nope.
Okay,
I got it.
thank you.
Take care. Mr. Abadi, have you had a chance to speak with the lawyer handling Mr. Twitchell's case? Okay, and they're working through what they want to do?
Yes.
Okay,
He stepped down to Judge Rock.
okay, all right. Ms. Cabrera left. She really wanted to take the plea. Are there, she stepped outside. Are we able to bring an inmate out now? Not right now? Pardon me? Oh, it's not that Gordon's right here. He went downstairs? Okay, do we have any plea we could take that's on bond?
I have some announcements.
Okay, let's do announcements.
So can we add on Mr. Silva Rodriguez?
Yep.
That is a trial, we're ready for Monday.
All right, let me write that down. One. Ms. Smith, you get that?
Yes.
All right, Silva Rodriguez, but we should get on the record what the offer is. So let's get Mr. Rodriguez up at the podium, please. All right, this is 25 SC 006-543, State versus Marcelo Silva Rodriguez. There's a speedy trial demand that was timely filed. That means we need to try the case this calendar or the next one. So we are compressing the process and treating today as also the final plea date. Ms. Wood, do you feel like you've got all the discovery you need to go to trial on Monday, which is what you said you're ready to do?
Yes, Judge.
Okay. Ms. Smith, if Mr. Silva Rodriguez wanted to resolve his case today, what would the state be recommending?
Yes, Your Honor, their offer was 5 served 30 days, with 30 days to be commuted to time served for the time he's already spent incarcerated. To break that down into counts, count 1 was 5 served 30 days, time commuted. Count 2 was to be no cross. Count 3 and 4 was 3 years probation, and count 5 was 12-month probation. For all of those counts, the record current for a total of 5 served.
Got it. And the count being dismissed was, you said 4?
Count 2.
Count 2. So that sometimes the calendar doesn't map the indictment. Is that the second of the 2 terroristic threats? Okay, got it. Everything else, it's a plea that results in an overall recommendation of what's effectively 5 years probation. It's 5 to serve 30, but it's reduced that to however many days he was in. Okay. So Mr. What would the conditions of probation be?
Drug and alcohol evaluation, for him to take a parenting class, no contact with the victims, and stay away from the incident location.
So is it pool?
Yes.
Okay, all right. Mr. Silva Rodriguez, do you feel like you understand what the state would recommend if you entered a guilty plea? Yes. Basically a non-custodial sentence. You'd be on probation for up to 5 years. You understand that? Okay. And your response to that is, no, thank you. I'd like to go to trial.
I got you. No, thank you.
Okay. If we go to trial on Monday, do you need an interpreter or are you able to understand what's going on?
I'm able to understand.
Okay. Ms. Wood, do you envision calling any witnesses for which we would need an interpreter?
No, Judge.
Okay. Ms. Smith?
No, Your Honor.
Okay, great. Then this will certainly be one of the cases on the list for Monday. Do you need Mr. Silva Rodriguez to stick around?
No, Judge.
All right, we'll see you Monday morning, 9 a.m. this
Thank you so
courtroom.
much, sir. Have a nice day.
Have a good weekend.
You too.
Thank you so much.
Oh, you're welcome.
All right, other announcements?
Yes, position 7, Daronte Jones.
Yes, I have an announcement on that. He contacted my office. He's been trying to reach you, he says, but has not been successful because you've been in court. He says he has the flu.
Yes, and so Ms. Niles was kind enough to give me the new number he's calling from. I am texting with him. I've talked to Ms. Smith. We are seeing if we can maybe reach a resolution today, and if the court would allow, if it works out, if we could have him appear via Zoom for that.
Definitely.
Okay.
If he is well enough to do that. If he's not, I
Okay.
have a staff member who's working through the flu who wouldn't even have been able to do that for a few days. But if he can, that's a great way to get closure.
Perfect. And then my last announcement for now is Mr. Daniels. I don't have his case number. I apologize.
21? Is this, wait, that's the one with the video. No, different Daniels, not Charlie Daniels. That's Mr. Majeski's client.
Mr. Craig Daniels, the walk-in.
Oh, right, Mr. Daniels from Now Texas.
Yes.
Yes.
So Ms. Rios spoke with him. He does qualify. I will file an injury of appearance, and I've exchanged contact information with him.
Okay, so I will set aside the bench warrant. Let me make sure that we have the latest and greatest. Do you have that case number?
I don't.
I'll look up the name at least and see what we get. Here it is. So, Mr. Daniels, you're gonna need, I still have you in Sauk Village, Illinois.
Yeah, so I'll go down to the,
You don't need to go anywhere. We've got a form here. And if you and Ms. Rios or Ms. Wood would fill it out, that's for you to put the new and improved address. And is this Ms. Nick's situation?
I'm emailing her. I think it is.
Okay, I think so too. Great. So I think that takes care of Mr. Daniels. He was on a trial calendar most recently, so I'll need to give you time to get up to speed and talk with Ms. Nix. And that was when the fallout happened between Mr. Daniels and Mr. Monsiagli. But you've got all his contact info?
Yes, Judge.
Okay. Mr. Daniels, do you have any questions?
no question. Since, I have my address now updated, I'll get all, anything that I have to include there.
You will get your notices to appear in court through the mail. All of the filings, your lawyer may file a motion or the prosecutor may file, that's all e-filing. That doesn't get mailed to you, but your lawyer will be getting copies. And so you just need to stay in touch with your lawyer. She could email it to you, whatever. But what you'll get through the mail are just the notices to appear. All right. Any other questions? All right. If that is a complete and legible form, if you give it to Deputy Gordon, do you need Mr. Daniels to stick around?
No, Judge.
All right. I will make a note to set aside the bench warrant. Do not get pulled over between now and like 48 hours, okay? Or at least do your best. Thanks. Do you have an update on that Charlie Daniels video?
I have to reach out to them together, he called me, I'm joining.
Okay,
So I'm.
you'll find out. Okay.
Well, that helps, you know, as far as next week goes, you're gonna get a conflict letter with like 5 older cases in them.
Okay, but what's going on with those older kids? Nice, you've got older cases, but if it's plea and arraignment or something,
So they're all dropping.
okay, and are they likely to go?
Just do it more.
Okay. Shouldn't we still figure out whether the video exists?
We should, Judge, you should, I know you'd like to know what's going on, and it occurred to me, I forgot to mention that before I left this morning.
Okay, well, please make sure that the, Mr. Hudson,
Yes, Judge.
thank you for being here. Did Mr. Sinkfield, you connected with Mr. Sinkfield?
Yes, Your Honor.
Excellent.
I was speaking to Ms. Taylor.
I appreciate it. Make sure you email a copy of the conflict to Ms. Nelson.
Ms. Nelson, yes, Judge.
Yeah, okay.
And, for today, we just waiting to hear back?
Well, yeah, the investigators reached out and Ms. Smith's been stuck taking pleas, so I think she's reached out to her investigator to see what the answer is.
Okay.
All right, do you have more places you need to go within this building?
Yes, sir, I gotta check back in with, Judge Cox.
Why don't you go do that?
Thank you, Judge.
Did you have other announcements, Ms. Wood? Nope, she's gone. Does Ms. Rios has announcements? All right, hold on, let me finish writing this note here about this bench warrant. Okay. Yes, Ms. Rios.
We can do the final plea hearing for Jason Bates.
Okay, why don't we do that? Mr. Bates? Is this your case? Good. There's a lot going on with that jacket. Can I see the back?
Yes, sir.
I like that. Okay. Let's get on the record. This is position 3125 SC 003-518, State versus Jason Bates, who is here in court with Ms. Rios. Ms. Smith is the prosecutor. Ms. Rios, we're going to have the final plea hearing. Do you have all the discovery that you think you ought to have in this case?
I believe so. Ms. Smith today mentioned there's a photo lineup that I don't have though.
Is it a stranger on stranger situation, or the photo lineup would be kind of unremarkable because it's
A stranger on
a
stranger.
stranger on stranger? All right. Do you have the photo lineup?
You don't, we reached out. though.
Oh, you don't have it either?
Mm-mm.
Okay.
Not in the state's position, but you said stranger on stranger, what was that question?
Oh, well, sometimes there's a photo lineup in a case because the police are being extra thorough, but the alleged victim says, my cousin shot me. I'm not saying you shot anyone, but he says, my cousin. Like, then they do a photo lineup. Yeah, it's this guy, but it's my cousin. I know him. As opposed to a guy wearing a jacket that says success is the best revenge shot me, but I don't know him. And then they do a photo lineup, and that is much more compelling evidence.
The photo lineup in this case, the witness is not the victim, so it's with people that he alleged to have known.
Okay,
So I don't know.
got it. Well, I mean, if you don't have it in time for the trial, you can't use it anyway, unless it's exculpatory, in which case then we've got a big problem. But it sounds like someone used the photo lineup and identified Mr. Bates, but the state can't use it if they haven't produced it in time. Other than the photo lineup, things look okay.
Yeah.
All right. Ms. Smith, what is the state's offer to Mr. Bates at this time?
The current offer for Mr. Bates is 10 years probation with some special conditions of probation.
Okay. Mr. Bates, right now, before trial, the offer is probation. A lot of probation, but just probation, no jail time. You understand that?
Yes, sir.
Is that something you're interested in pursuing? No, you'd rather go to trial?
Yes, sir.
Okay. You free next week?
Yes, sir.
Good. You understand that today you could enter a plea, and if I sentence you to more than what Ms. Rios asked for, you could withdraw your plea. So she could ask for less probation, and if I didn't agree with her and gave you more than what she asked for, you could back out of it.
Yes, sir.
After today, you may decide, you know what, I don't want to go to trial. It's not going to end well. You can still enter a plea, and the state may still offer probation, but what you don't get to do is back out of the plea if you're unhappy with the sentence. Understand that?
Yes, sir.
Sounds like you got it. Then stay in touch with Ms. Rios. Your case is going to go on the list. I just don't know the order in which we're going to call things in. But I'll expect to see you here in court Monday morning.
Yes, sir, I will.
All right, good. Anything else, Ms. Rios? Ms. Smith?
No, Judge.
All right, I'll add it to the list. Do you need Mr. Bates to stick around?
No, he's free to come.
See ya.
All right, so you have a great day.
Can we do Silas Baker now? Okay,
I told him, I said, I think I'll be done by 12.
you will.
just a little lesson, like, and then ETA, I'm like, I know y'all have a billion other things.
Right, you can't be the only one.
Yeah, the calendars are usually about 100 positions,
Yikes, who does that?
and all the time.
Huh.
This is, Mac.
Really? Okay, what's the case number?
Into SC 182-064.
Thank you.
And he's got 7 years, 7 years.
All right. Thank you. Well, let's get on the record. This is position 28, State versus Silas Baker, 25 SC 003467. Good morning, Mr. Baker. I'm all right. You doing okay? Good. We're gonna need, I don't know if maybe we need to have him at council table.
That's maybe it.
Yeah.
Yeah.
Mr. Baker, you're 100% stay in the wheelchair. I just need you closer to a microphone so the court reporter can hear you. So I think we're gonna roll you around to the table over there so you can be closer to the mic. Right. All right, let's do this. Excellent. Okay. All right, so Mr. Baker, I'm not gonna be able to see you directly. I can see you on the screen though. Are you able to hear me?
Yes, sir.
Excellent. Mr. Baker, Ms. Cabrera tells me that you're ready to enter a plea in your case. Is that right?
Yes, sir.
Okay. Ms. Smith, who is seated up here to my left, up at the witness stand, she's the prosecutor on your case, and she's going to ask you a bunch of questions about your case. You need to answer her questions as best you can. Will you do that?
Yes, sir.
If you at any point have a question or need a break or are confused, will you let me know?
Yes, sir.
Excellent. Then, Ms. Smith, when you are ready.
All right, thank you, Your Honor. Mr. Baker, may you raise your right hand?
Yes, sir, ma'am.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Can you state your true, correct, and legal name for the court?
Silas Baker Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Yes, ma'am. I'm on some medication, but I don't know what kind it is.
Mr. Baker, what do you take the medicine for?
I don't know that they don't told me I'm on diabetes. I take diabetes medication. I take blood pressure medication. I don't have the stroke and 2 heart attacks.
Whew. Okay, so you're taking a lot of meds, but they sound like they're meds that are keeping you safe and as healthy as can be.
Yes, sir.
Did you take any medicine this morning?
Yes.
Does that medicine make you sleepy or drowsy or confused?
No, sir. I'm aware of.
Okay, you feel like you understand what we're doing here right now.
Yes, sir.
Good. Okay, thank you.
How old are you, Mr. Baker, and how far have you gone in school?
59. I went to the last grade out of 10 to 9th.
Are you able to read, write, and understand the English language?
I can read a little bit. Have a problem with reading.
But you can understand what we're saying.
Yes, sir. I hope I can.
Okay, well, if you can't, you're going to tell me, right?
Yes, sir.
Good.
Do you understand, Mr. Baker, that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances about this case?
Yes, ma'am.
Do you think you need more time to speak with your attorney?
No, no, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for purposes of this plea?
So wait.
Mr. Baker, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years served 1 year in custody?
Yes, ma'am.
Are you also aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you were charged with a crime in the future, that this plea may be used to enhance that sentence?
Yes, ma'am.
Are you currently on probation?
Yes, ma'am.
Do you understand that because you're currently on probation, this guilty plea, your probation may be revoked based on you entering this guilty plea today?
No, ma'am, I didn't,
I can handle everything in the same.
Yeah, Mr. Baker, you are on probation for another case. And what I'm planning on doing, but we'll talk through it, is having your revocation be the same thing as your sentence in this case. But that way you don't have to get dragged into another courtroom to deal with that other case. And it's something Ms. Cabrera knew about and I think was negotiating with the prosecutor. Are you okay with that?
yes, sir.
Great.
Mr. Baker, do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, that means that this guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? And I'll list them one by one. The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial. Do you understand? Oh, go ahead. I'm sorry.
Yes, ma'am.
Counsel, are you satisfied your client understands these are the rights that they'll be waiving by entering into this guilty plea?
Yes.
Mr. Baker, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea?
No, ma'am.
And as to indictment 25 SC 003467, how do you plead to count 1, aggravated assault, and count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies?
Excuse me, I ain't had no firearm.
No, and it's well, we're going to talk about your case in a minute. But what Ms. Smith is letting you know, Mr. Baker, is that you're already a convicted felon. You've got that case from Judge Whitaker about cruelty to children that we'll be working through as well. And it's just, you're not able to have a firearm in your household. You can't have one on you, can't have one on your bedside stand, you can't have one in wherever it is you're staying. That's just a consequence of having gotten in trouble before, okay?
Yes, sir.
Ms. Cabrera, was this under effort?
Yes, it will be an hour.
Mr. Baker, are you pleading guilt? Is it your decision to waive these rights we just talked about and enter a guilty plea because you are in fact guilty?
It's good to know. It's just that good to know.
Guilty on the outfit.
Okay. And are you pleading guilty because you have decided that this is in your best interest to do so?
Yes, ma'am.
And are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Say it again, ma'am.
Yes. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea, but if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
This is what we talked about in the back. Remember I gave you those dates? Better now. Okay. You understand?
Yes.
Okay. Do you also understand that this must be completed within 30 days of today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Okay, thank you, Mr. Baker. Your Honor, if this case would have gone to trial, the state would have been able to prove that on March 14th, 2025, Officer Jay Bueller, that's Bouler, was dispatched to 375 Auburn Avenue Northeast for a shots fired call. When the officer got on the scene, he spoke with the caller, Miss Ayanna Flagg, who advised the officer that she was shot at by a known male. Miss Flagg said she pulled into.
A known or an unknown?
It says by a known male. They knew each other.
Got it. Thank you.
Ms. Flagg said she pulled into the parking lot of this address, 375 Auburn Avenue, and she parked her car. As she got out of the car and locked the door, she saw Mr. Silas Baker, the defendant in this case, who was in a wheelchair. He came behind her and behind the vehicle and screamed, "I'll kill you, B." After that, Ms. Flagg said she don't know why Mr. Baker was saying this to her. However, at that point, Mr. Baker reached into his pants and pulled out a handgun. Ms. Flagg said it looked like a silver revolver with a black handle. At this point, Mr. Baker started firing shots toward Ms. Flagg. She ran behind the truck and started to run away from the shots that were being fired. There was a security guard who said he saw people starting to run in this matter. Ms. Flagg then said she saw Mr. Baker go away from the scene and called the officers. When the officers got there, she told them everything that she knew. Mr. Baker was not arrested at that time, but was arrested, I think, a few weeks later and charged with aggravated assault and possession of a firearm during the commission of a felony. And those are the facts of the case. Regarding the negotiated plea between the state and defense, we've agreed to, for count one, 5 years to serve 1. And for count 2, 5 years of probation to run consecutive for a total of 10 years to serve 1. Regarding this case, Your Honor, I did have a chance to speak with the victim actually this morning, and she said that she was okay with the offer that was given in this case. She wants this to be a lesson for Mr. Baker, that even if you're handicapped or you have some type of disability, that you cannot go around harming people, and that you need to lead with love. And she's happy that she's alive because the only thing she had in that moment was God. Those are the words of the victim.
Okay.
Also would just want to put on the record that Mr. Baker is a recidivist under A and C. But that's all from the state, Your Honor.
So a couple things. One, you are not seeking to recidivize him. He is recidivizable, but you're not recidivizing him.
Yes.
Two, and you may have said it before, I didn't catch it, special conditions of probation.
Yes, I did not say no. Special conditions of probation would be the Fourth Amendment waiver, no weapons, to forfeit any firearms that you may have.
Was when he was arrested, did they recover a gun?
No.
Okay. All right.
No contact with the victim, and then that's all. I don't have a stay away from the incident location.
Okay. All right. Thank you. Ms. Washington, can you share what you've got in terms of criminal history for Mr. Baker?
Yes, Your Honor. I have 38 arrest cycles. There's a 2023 felony conviction for cruelty in the first and misdemeanor conviction for cruelty in the third. And as mentioned, he's currently on probation for that case. There's a 2008 felony conviction for aggravated assault and possession of a firearm during. A 2004 felony conviction for forgery in the first. 2001 felony conviction for possession of cocaine. A 98 felony conviction for aggravated assault. 93 felony conviction for dangerous drugs, 92 felony conviction for violation of the Controlled Substance Act, 2 separate felony convictions in 1990 for burglary, an additional 1990 felony conviction for aggravated assault and giving a false name. There was a probation violation last year, an FTA from 2023, and nothing further.
Well, that was plenty. Thank you. All right. Ms. Cabrera.
Yes, Judge. So it is an offered plea. No, he was not arrested with any weapon. This was a woman that he had a relationship with. It had obviously gone left. He's got allegations of his own that, she had kind of robbed him, took some money from him, had his ID, things like that. There was some, I guess it's the equivalent of like he took a food stamps. She had some food ordered, delivered to her house, so they're going back and forth on that in any event. But he does understand that it is perhaps in his best interest to go on ahead and resolve this way because a trial would look completely different.
Right.
So he does understand that, and also given his physical situation and things that he does have going on, taking that chance is probably not the best. So I just ask that John accept his plea as negotiated, allowing him to enter it under Alford.
Okay. Got it. Mr. Baker, is there anything you want to add to the things that Ms. Cabrera just told me?
No, sir.
You understand that as a condition of your sentence in this case, you'll need to have no contact with Ms. Flagg.
Yes, sir.
You know who I'm talking about?
Yes, sir.
All right. Were you guys ever boyfriend, girlfriend? Was it ever like that?
Something like that. No, sir, though.
Okay. So being away from her is not going to be a problem.
No, sir.
All right. Do you have a place to stay when you're done with your sentence?
Yes, sir.
Okay. And is that in Atlanta?
Yeah, 72 Highway Street. That's where I was staying.
Okay. How long have you stayed there?
I've been staying up 3 years.
Okay. Yep, 72 Howell Street. That's what we got in the system here. Is that anywhere near Auburn Avenue?
Yeah, that's a house right there by coming from Dr. King's house.
Okay.
I stay in one of them houses. I stay in the basement. I got the whole basement.
Well, it sounds like you got a good spot. You shouldn't do things to jeopardize that. Does Miss Flagg live around there?
No.
No?
So
Where does she stay?
he was staying with her daughter on Boulevard.
Okay. All right. Well, Mr. Baker, I find there's a factual basis for your plea. I understand this is a he said, she said, and Ms. Flagg is saying you shot at her. You're saying you didn't even have a gun. You carry with you, unfortunately, a pretty messy criminal history. And so it could well be that if a jury heard about some of that, I don't know that they would, but if they did, they might think that Ms. Flagg was onto something when she said, this Baker guy had a gun and he assaulted me. have a few convictions for aggravated assault with a gun. That doesn't mean you did it this time, but it's a reason to not go to trial and to do an offered plea. But if the jury did believe what Ms. Flagg said, they could find you guilty. I also find that your plea is knowing. That means you've understood what we talked about. Do you agree with that?
Yes, sir.
And it's voluntary, meaning no one's forcing you to enter this plea, but you've decided that's what's in your best interest after you've had time to think about it and had good conversations with Ms. Cabrera. Do you agree with that?
Yes, sir, sir.
Ms. Cabrera, can someone in my office sign the indictment for you? Ms. Smith?
Yes, Judge.
And Mr. Baker, is it okay if we electronically sign your name to the indictment indicating your offered plea in this case?
Yes, sir.
Well, we'll do that. So what I'm going to do on count one, Mr. Baker, is sentence you to 1 year to serve. You will get credit for the time you've been in, but you're going to be in a little longer. Count two, I'm going to sentence you to 5 years probation. It has to run consecutive to count one. That's a little less than what the state asked for, not because I think they were wrong, but gosh, you're 59 now. And so by the time you're done with this probation, you're going to be about 65 years old. If you're not done getting in trouble by then whatever judge gets your case when you're 65 ought to just say, let's send the guy down the road. But I hope that you are finished getting wrapped up into situations where you get into trouble, either because you cause it or just because there is trouble and you're around. You feel like you're ready to be done?
Yes, sir, sir.
All right. You can just stay quiet in the basement at Howell Street.
72 Highway Street.
Yep, that's what it is. It will be a special condition of your probation, Mr. Baker, that you have no contact with Ms. Flagg. It will also be a special condition of your probation that you take a drug and alcohol abuse evaluation. You'll meet with a doctor or nurse, someone like that, who's going to talk to you about what you drink, what you smoke, whatever you might do. And if that person recommends any treatment, that treatment will be part of your probation. Okay?
Yes, sir, sir.
All right. You are on probation in 22 SC 182064. That's the cruelty to children case that you pled to in front of Judge Whitaker. You got about 7 years of probation left on that. Ms. Cabrera, there is a petition out there. I just don't know that it was necessarily on the calendar for today, or did you expect that we'd be talking about revocation as well?
No, I knew we had one, and then I spoke with probation this morning.
Yep.
Kind of verified exactly how much time was left, and
Yep.
she said that we could resolve it today.
Good. All right. So just in case you waive any due process notice concerns that would arise from talking about the revocation today. All right. Well, given Mr. Baker's conviction in the aggravated assault case, I find there's a basis to revoke his probation in the cruelty to children case. And I will do that. And I'm going to revoke 5 months of probation in that. What I'm going to do is revoke 7 months and then just reinstate the balance in that case. That'll leave it at just about 7 years of probation. This case will run concurrently with that, and we'll move forward. Mr. Baker, do you have any questions about anything we discussed?
No, sir, not right now. I can't think of them right now.
Say that last part again?
I said I can't think of them right now.
Okay.
He probably does need to hear you say that he's going to receive credit for the time that he served.
You will, for your aggravated assault situation, receive credit for the time that you served. Okay?
Okay.
All right.
For the time I got locked up.
You were, I don't know when you got locked up, but you've been in for a while now. I count 240. Yeah.
8 months.
Yep. So you got that going for you. All right. If there is nothing else from Ms. Smith, then I think we're done. All right. Thank you.
Thank you.
We sure can. Okay. Why don't we do that and then we can take a lunch break?
Okay.
You have to let me go.
Yeah, I thought you were done.
I'm gonna let you have to say it.
Oh, and Ms. Cabrera, thank you for being here. You're free to go. I think they want you in Gwinnett.
Thank you. I'm gonna get there, and they're gonna be on their lunch, hopefully they have 12:30.
What position is it?
14. I mean, not 14, that's it.
Yeah, you said Brightwell. He already pled.
I mean 32.
Oh, that's a very different number. All right. Mr. Williams? Hey, did Ms. Wood talk to you about a plea? Okay. I think we're gonna do it now. But we need Ms. Wood. Oh, we could use Ms. Rios. Okay. While we're waiting on Ms. Wood, let's just sort through what remains. Mr. Sinkfield, I saw you. There you are. I think you're lawyer. You met Mr. Hudson now? Okay, and he's talking to the prosecutor. All right, so we'll hold off. We may be able to resolve your cases. Ms. Wood will tell us about Mr. Jones, Baker, Comer, Burden. Is Mr. Burden here? Can't remember what she said about Mr. Burden. You think he is? Oh, is he the gentleman in the wheelchair? Okay, so he's here. Mr. Twitchell, what are we doing with your case? Is an open plea a non-negotiated plea? Okay, all right. And then Mr. Sherman is still a plea?
Yes, sir. I just need to finish speaking with them.
What we're gonna do, if it's all right with you, is take Mr. Williams's plea. Apparently there's a victim here and has been here all morning, so we'll work through that and then we can break for lunch, so that we can, tighten up the other loose ends. So that's Mr. Sherman, then Charlie Daniels, you gotta let us know what's happening with that video. Tyrone Patterson, is Tyrone Patterson, I should put that on the list of things to go to trial?
So Tyler, that's the 5 participant case.
Oh, right. I always forget that. I need to cross out that. Yes, never mind. I don't want anyone to panic. Jason Bates.
That's for signature.
Yeah, that's on my list. And then Williams is a plea and all right, that's it. Okay. Is it a negotiated plea? You're not sure. If you and Mr. Williams are ready, is it a negotiated plea?
It is for the most part, Judge. It will be an offered plea. I didn't have a chance to ask Ms. Smith if she had any objections to that. And then there might be a couple of things that we need to request about some of the special conditions.
Okay, but the bigger moving parts, there's not disagreement on.
Correct.
Okay.
Judge, if I understood you correctly, this is the last plea you're gonna take before lunch, not the excuse until after lunch break.
Correct. Why don't we reconvene at 12:45? All right, thanks. Yeah. Anyone who is here for something that's not Roderick Williams, you're free to stay. Courtroom will be open, but we're gonna give court reporter and others a break and reconvene at 12:45.
Thank you, Judge.
All right, Ms. Rivers, you ready?
Ready?
Great. This is position 32 on the trial calendar. State versus Roderick Williams, 25 SC 003621. Mr. Williams is here in court with his lawyer, Ms. Wood. We have Ms. Smith for the state. And Mr. Williams, you ready to go forward with a plea?
Yes, sir.
Okay. Ms. Smith's going to put you under oath, ask you a bunch of questions. Please answer them truthfully and completely. And please let me know if you have any questions. Will you do that?
All right.
Great. Ms. Smith?
Yes, thank you, Judge. Mr. Williams, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Roger Williams.
Are you at this time taking or under the influence of any alcohol, drug,
No.
or medication?
I'm sorry. No.
Make sure you wait till the question's done, even if you know the answer, because the court reporter can only write down what one person is saying at a time.
Yes, sir.
Is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone in school?
35, 11th or 12th, one on. It been a minute.
Did you graduate from high school?
Nah.
Do you have your GED?
No, sir.
Okay.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
And have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you think you need more time to discuss your case with your attorney?
Nah.
And are you satisfied with her services?
Yeah.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Do you waive the formal reading of this indictment and any and all defects in the indictment for purposes of this plea?
We do.
Mr. Williams, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, ma'am, I don't have any warrants.
Do you understand that you are now entering a non-negotiated well, you said this was negotiated, right? The
Yes.
biggest part, okay. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years probation?
Yeah.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and run those sentences consecutively?
Yeah.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with another crime in the future, that this plea may be used to enhance that sentencing?
Yes, ma'am.
Are you currently on probation?
No, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or your ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you would be charged with another felony offense?
Yes, ma'am. I absolutely understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty today, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you?
Can you repeat the question?
Yes. Which, the one I'm doing right now?
Yeah.
Okay.
You can say that again.
Yeah.
I'm sorry.
You're good. Do you understand that by pleading guilty, you are giving up the following rights? And I'm about to say them one by one. The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Do you understand?
Yes, ma'am.
Okay.
Counsel, are you satisfied your client understands these rights they'll be waiving by entering into this guilty plea?
Yes.
Okay. Mr. Williams, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea?
No.
Is it your decision to waive these rights we just talked about and enter a guilty plea because you are in fact guilty?
I'm pleading guilty in my best interest.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
As to indictment number 25 SC 003621, how do you plead to count 1, aggravated assault, count 2, possession of a firearm during the commission of a felony, and count 3, possession of a firearm by a convicted felon?
I'm pleading guilty in my best interest.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Oh, yes, ma'am.
And do you understand that you have to do that within 30 days from today?
Yes, ma'am. Understood.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Okay. Yes, ma'am.
Thank you, Mr. Williams. Your Honor, if this case were to go to trial, the state would have been able to prove that on Saturday was March 1st, 2025 of last year, officers were dispatched to 415 Fairburn Road Southwest. That is the City Park Apartments, apartment 1001. And this was concerning a gun-involved incident. When the officers arrived, they spoke with the victim, in this case, Ms. Takira Kersley. And I'm sorry if I'm saying your last name correctly. It's spelled Kirksey, who stated that she had a disagreement with her aunt, Ms. Williams, who is the mother of the defendant. So the defendant and the victim in this case are cousins. She stated that after she had this altercation or conversation with her aunt, that her aunt called her son, who is the defendant in this case, to tell her that the victim had been talking reckless to her. In response, the defendant came to the City Park Apartments and at this point engaged in a verbal altercation with the victim in this case. At a point during the altercation, he pulled out a weapon, pointed it at Ms. Persky, and threatened her that he would shoot her, or they were just going back and forth with the argument. At this point, the victim, Ms. Kursky, did call the police officers. They came out, but by the time they got there, Mr. Williams was gone. He was not arrested on scene, but he was arrested, I believe, a couple of months ago. And those are the facts of the case. Regarding the negotiated plea between the state and the defense, we have agreed to, for count 1, a sentence of 5 years probation. For count 2, a sentence of 5 years probation to run consecutive. And for count 3, a sentence of 5 years probation to run concurrent to count 5. In this.
Count 1 or count 2?
I mean, no.
There's no
3
count
is
5.
Yes. Count 3 is to run concurrent to count 1. My
Okay.
apologies.
It's okay.
And that's for a total of 10 years probation. Regarding the special conditions of probation, we're going to be asking for no contact with the victim whatsoever, indirectly or directly. There has been reports since this incident that the defendant has tried to reach out through other people to the victim, so we're asking for no contact at all. For the defendant to stay away from the incident location. We do understand that this happened at City Park Apartments, apartment 1001. However, the state is asking for the defendant to stay away from the entire City Park Apartments because that increases the likelihood that he will see the victim because she lives there. We're also recommending 100 community service hours for the defendant to be gainfully employed and show proof every 90 days, for him to obtain a GED, to complete an anger management course, and also for there to be a Fourth Amendment waiver. Also, Your Honor, in this case, we do have a victim that is present that would like to give a statement, but as far as anything else from the state, that's all.
Okay. Ms. Kirksey? Hey, how are you? So I'm gonna have you follow Deputy Gordon's directions or where to.
Oh, Misty.
Oh, okay, then why don't you sit tight till she gets here, okay? I want her to be here with you. So, we're texting her right now, and we're gonna come back to you. I'm not ignoring you. I'm just gonna keep moving the process along. Okay, thanks. And thank you for being here. Ms. Washington, criminal history information on Mr. Williams, please.
Yes, Your Honor, there are 14 arrest cycles. There's a 2021 felony conviction for possession of cocaine and possession of a controlled substance out of Cobb County, a 2022 felony conviction for possession of a controlled substance in Polk County, 2017 felony conviction for 3 counts of criminal damage to property in the second and willful obstruction out of Douglas County, a 2015 felony conviction for possession of a firearm by a convicted felon out of Cobb County, a 2011 felony conviction for purchase, possession, or sale of marijuana out of DeKalb County, 2008 first offender probation for possession of a controlled substance, simple battery, and possession of marijuana less than an ounce out of Rockdale County, and that was sealed in 2017. There were probation violations in 2021 and 2020 out of Douglas County. Nothing further.
Thank you. So this is your first Fulton conviction. You've been touring the state. Cobb, Polk, Douglas, DeKalb, Rockdale. Ms. Smith, your predecessor in here filed a recidivist notice. Are you withdrawing that for purposes of the plea?
I believe so.
Okay. Ms. Wood, we're taking things a little out of order because we're waiting for the victim advocate to get here. But what do you want to tell me about Mr. Williams and this situation?
Yes, Judge. So just to get it on the record, Mr. Williams obviously is pleading because he believes it's in his best interest, but there is, as our position, there would have been not plenty, but there was some reasonable doubt with some of the video evidence. But he is making this decision because he doesn't want to run the risk of trial.
Sure. Is the reasonable doubt that he was even there or that there was a gun involved?
That there was a gun involved.
Okay, so he's not saying I didn't show up and maybe there were words and maybe unpleasant words between Ms. Kirksey and Mr. Williams.
Yes.
His position is I didn't ever produce a gun.
Correct.
Okay.
And our position is the video is unclear, could have been a cell phone, could have been something else.
Okay.
It just seems like a very messy family situation that kind of spun out of control. Judge, he did serve 66 days on this case, so we would ask that that is reflected in the final disposition. He was in custody March 13th, 2025 until May 17th, 2025.
And was that Mr. Williams just time it took to post bond or did you have no bond? What was?
When I caught the charge with my cousin, it violated the probation that I was on at the time.
Which
Douglas.
Douglas.
And I got off probation May 16th, finally after 19 years. And
going back on.
Yeah. So I had to, after they dropped the hold, then I could bond out. So I was free.
Okay, so you had to hold, it didn't make sense to post a bond until you cleared that up.
Yeah, so now I'm not on probation, but about to go back on.
You are?
Yes, sir.
Okay.
And Your Honor, just in terms of the special conditions, so he suffered a workplace injury. So I've explained to him that is the state's recommending the gainful employment. I'm just putting that on the record because I'm not sure how the clearance works for that.
Okay.
It was like a workman's comp situation.
Yeah.
He also, I know at one point he was working to complete his GED. You didn't finish it, right?
No.
Okay. Judge, Mr. Williams does not feel that he needs a GED to be successful in life. So I've explained that that will be in the discretion of the court. And then finally, he also told me he's already done an anger management class since then. I've explained to him, generally, if you just show it to probation, they'll, see that and work with you on that. And then finally, Judge, he is asking if the court would consider suspending the probation after 5 years of compliance.
Okay. The no contact provision is not negotiable. I'd prefer to stay away from the whole apartment complex. Any reason you need to be at that apartment complex? It's complicated because it's family and I have an
That's what I
auntie.
was gonna say, cause, okay, so this is the thing.
No. One step at a time. I'm gonna give you a chance to unload if there are things you want to unload on. But right now, I just want to know, you don't live at the City Park Apartments.
I don't, but I have my other cousins. Like, I love all my cousins. Like, we just got in a
Okay,
disagreement.
I hear you, but who?
I love her too.
Okay, well, she's wanting you to love at a distance.
That's
okay?
cool, but
And so I'm just trying to understand who else stays at the City Park Apartments that you need to see.
just friends and stuff. I've been over
Okay.
there for 5 years.
All right. Well, good news is there are lots of apartment complexes in
Right.
Georgia.
Absolutely.
And your friends can come see you. If they're good friends, if they're missing them, some Roderick Williams, they'll go to wherever you are.
They're right too.
All right. I didn't make sure you didn't have a kid there, or like that's where my mom stays. That's more
I had an
complicated.
apartment over there.
But you don't anymore.
No more.
Okay. Don't get another one. Okay. I think it would be helpful if I heard from Ms. Kirksey before Mr. Williams and I talk a whole lot more. Is there, would you be comfortable, Ms. Kirksey, if Deputy Gordon stood by your side, or were you having the victim advocate read something for you? Oh, she was gonna read it for you? Okay, if Ms. Smith read it? Oh, she's on her way? Okay.
Deputy Miller just went to get her.
Okay. So Mr. Williams, tell me about the workplace injury. What is your injury?
I cut my thumb all the way to the bone at 4840. They have not cleared me to work. It's been over a year and some change.
Okay. They haven't cleared you to work using that hand, or you can't do like, could
Cleared
you
me
be
to work yet.
you
Like,
can't-
I'm still going through therapy.
Okay. And is it your dominant hand, like the one you
It's
write with?
right-handed. I have to relearn. It won't even bend or nothing. Like,
Okay.
it's stupid.
What job did you have when you got cut?
I was a saw operator.
Okay, I can see how one would get cut. What kind of work are you trying to get back to?
I'm probably gonna go back there when they clear me.
Being a saw operator. Where are you a saw operator?
4840.
I don't know what that is.
It's a pallet place, the biggest pallet place. One of the biggest
Okay,
pallet
so you're
places.
cutting wood to make pallets. Got
The more
it.
work I get, the more work I cut, the more money I make. So it was,
Got it. And that was a job that worked for you. So your hope is to go back there.
Yeah, because after
Have they
catching that charge,
indicated? I'm sorry.
I said, yeah, because after catching that charge, I kind of got evicted. So I lost everything. So I'm just trying to like get back on my feet, if that makes sense.
Did 4840 say they'd take you back?
I ain't talked to them because I haven't been cleared.
Okay.
They actually fired me afterwards, but I ended up still getting workman's comp, and it's been over a year. So,
Okay.
but I'm pretty sure I could get the job back there. Just being honest.
Does the doctor or physical therapist have a timeline for you as to when you should be good to go?
No, sir. I thought about a year ago I would have been good to go.
Are you still getting workers' comp?
Yes, sir.
Is that how you're putting food on the table?
That's how I pay my rent.
Yeah. Okay. Do you have kids?
Yes.
How many kids?
2.
Do they stay with you?
Yeah.
Who stays in your household along with you and the kids?
My wife.
Okay. How long have you been married?
3 years now.
Got it. Does she work?
Yes, sir.
What does she do?
She just started at the post office.
Is she a letter carrier or she's at a post office?
She just
Oh, she
started.
just started.
So,
Okay.
we
So who
go,
knows?
Even,
Okay. All right. So you're hoping to get back to work, not cleared yet. You're still getting workers' comp. And is it your understanding that you'll get it as long as you're not cleared to work?
Yes, sir.
All right. How old are your kids?
14 and 12, going on 13.
Big kids.
Yeah.
So they're in school. Where do they go to school?
Benjamin E. Mays, and I can't think of the other one. It's still on the same street though.
Okay. All right. Was there more you wanted to share with me about your situation?
Currently, if you can, like, make the fines, because I'm currently going through a hardship, honestly.
You'd like me to waive the supervision fees for a little while?
I stay in the efficiency lodge, so really my whole workman comp go toward my every week.
Okay.
To be honest, so I don't know, like, if I would be homeless just trying to take care of probation and then risk going to jail because I don't want to be, you know what I'm saying? I don't want to be in that type of situation.
Understood.
And I know y'all work with people or whatever. As long as we voice it and speak to you guys, right?
Okay. Got it. Is this the person? No. That's okay.
I'm waiting for Misty to read her victim statement. You have it? Okay. We can.
Great.
Continue.
All right, Ms. Kirksey, come on up and stand next to this young lady, please.
Right here.
Okay.
Okay, just don't make faces.
Oh.
So first, thank you for being here. I appreciate that you're here. And I know this is a difficult situation. It sounds like what you wrote, this employee of the DA's office has as well. So she's going to read it into the record. And then I'll ask you if there's anything you want to add to it, okay? All right.
Go back and get
So my name is Deputy Lucia Williams, first name Lucia, last name Williams, common spelling Williams. And I'm reading this statement on behalf of the, it says, I'm here today to give my statement. The decision for me to come here was hard after being threatened continuously from the defendant and other associates. Me and my family received threats for trying to get justice for myself. I am a social media influencer, and the defendant went to social media making false accusations. As a result of that, I received backlash and seen a decrease in income. After the incident, I was traumatized and didn't want to be home after. Since the incident, I've had flashbacks and horrible dreams. Also not able to sleep throughout the night. To this day, I am now traumatized from guns and do not want to be around any. Lastly, hearing probation feels like a slap in the face to me. The incident could have went differently that day, and if it did, I wouldn't have been here today. I want to be able to make sure he learns his lesson and won't do this to me or any other person who doesn't deserve this.
Ms. Kirksey, when you say that you received threats, were they things that came directly from Mr. Williams, or they were clearly from him but through other people? And were the other people relatives or friends?
Like he said, he's been out there for 5 years, so he knows a little more people than me. But my brother's ex-girlfriend is out there, and she calls him and says, "Oh, he said to beat me up when she see me." That's one. And also his wife, family, was contacting my mom saying that they see her at the bus stop, they're gonna jump her. This is after he was arrested, and they found out that, it was because of me.
Okay. I can understand why all those would be real unsettling. One of the conditions of Mr. Williams's sentence will be that he have no contact with you, direct or indirect. Direct is pretty obvious. That's him calling you or texting you or posting on your Instagram or whatever, and it's clearly Mr. Williams. But indirect means no one on his behalf as well. So I'm hopeful. This was a while ago, almost a year ago, that it's died down. But there's going to be maybe a hiccup right now because Mr. Williams is taking care of his business, and that might upset people who care about him. And you need to let Ms. Smith or Deputy Williams or someone know if you're getting more communications that you think are somehow associated with this case. What you need to not do, though, is respond back or do any outreach to Mr. Williams. If you were to text him, he is stuck. He's not supposed to communicate with you. And so it's not right for you to do any outreach to him. I'm not saying that you would.
Yeah, I blocked every.
Okay, good. It just needs to, good. It just needs to be both ways. And this is different. It's not, I want to be real clear, it's not boyfriend, girlfriend, anything like that. But sometimes we get cases where the victim says, I don't want any contact. And then it's like, hey, I miss you. And that's not you. But just make sure because your family, that there's not an invitation to some family event and oops, I sent it to. Okay. But I do want you to make sure you're letting someone from the DA's office know if there's any more contact, because that's the quickest way for probation to end poorly, is if you are genuinely being harassed. Now, if someone drives slowly by your apartment in a dark car, that may have nothing to do with Mr. Williams. And so I'm not saying you shouldn't be concerned.
To see him, I'm sorry, I continue to see him even after the case.
Okay. Well, if you see him at the City Park Apartments after today, that's a problem for Mr. Williams. If you walk into a Kroger grocery store and he happens to be shopping, he needs to get out of there, but that's not on him. But if it is your space and he shows up in your space, that's the kind of thing, take a picture, get it to these folks, and then we'll work through it. Okay? I appreciate you being here, and I'm sorry you had to go through that. Any questions about anything? No? Okay. Are you back to, yes?
Make sure it's no contact, nothing.
Nope. I'll make it real clear.
It's been a little road after it, so
All right.
thank you so much.
You're welcome. Thanks for filling in for the victim advocate. All right, Mr. Williams, back to you. I find that there is a factual basis for your plea. I also understand, as Ms. Wood has pointed out, there are two sides to every story. You're not saying you weren't there. You're not saying maybe there weren't harsh words. Your version of events differs from Ms. Kirksey's. But you've decided, and I think wisely so, it doesn't make sense to go to trial on this one because a jury could hear everything and they could come down in a way that ends poorly for you. And so you're entering this offered plea. Is that a fair summary of where we are?
To a degree, yeah.
What am I missing?
Just you heard lies. Like I haven't tried to get in contact with nobody.
Good. And let's keep it that way. You know what? I'm not taking sides right now. I'm gonna give you some real clear operating instructions, and I think you're gonna be able to do that. I'm not changing what we're gonna do here. It was important that I heard from Ms. Kirksey. I think it was important that you did. Whatever happened on February 28th of last year was real upsetting to her. And that's how we need to leave it. I also find that your plea is knowing, meaning you've understood that everything we talked about. Is that fair?
Yeah.
Okay. And it's voluntary, meaning you are not enthusiastic about being up here, but you've decided after thinking about it, maybe praying over it, talking to a real good lawyer about it, that it is in your best interest to handle your business this way rather than in a different way. Is that a fair statement?
To a degree.
Okay. What am I missing here?
I mean, to sum it up, I'm gonna put it that way. To sum it up.
To sum it up is fair enough. Okay.
Fair enough.
And that's all I'm doing right now is summing up a real complicated thing into just a few lines. I get it that I'm simplifying things. Ms. Wood, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Ms. Smith?
Yes, Judge.
Mr. Williams, instead of passing paper around anymore, what we do is electronically sign documents. Do I have your okay to electronically sign your name to the indictment indicating your offered plea in this case?
Yeah.
Okay,
Yes, sir.
we're going to do that. So, Mr. Williams, what I'm going to do in your case is sentence you on count 1 to 5 years to serve 2 months with the balance probated. Count 3 is 5 years to serve 2 months with the balance probated. Those run concurrently with each other at the same time. Count 2 has to run consecutive to count 1. It's 5 years, and I'm going to suspend that for now. I'm going to tell you why and what the conditions of that are.
Okay.
So your total sentence is still 10 years. Serve 2 months. You'll get credit for the time you served. And then you're going to be on probation for 4 years and 10 months, followed by 5 years suspended. The one special condition of your suspended sentence is that you obey the laws of Georgia, the other 49 states, and the United States. So if we fast forward 6 years from now, you're actually still under sentence. No probation, but if you get arrested for anything, the state can say, hey, he's got this suspended sentence, and the only condition he had was don't get in trouble. So if you get in trouble 6 years from now, we actually could come back and I could revoke some of that suspended sentence.
Suspended sentence?
The suspended sentence. The part that is more immediate and that you start now, even though you've been on for 19 years, whatever the number was, and just got off, is probation. And here are the conditions of your probation. Number one, most important, is no contact with Miss Kirksey. And you got it, but I need to say it on the record so there's no confusion. If we're together again in 6 months, like, Judge, I thought it would be okay if I did X. It's not. You don't call her, you don't write her, you don't text anything, you don't put something on social media. You don't put on your own, do you do social media?
I do social media. I have one question.
Well, let me finish what I was going to say, then you should ask.
Yes, sir.
So what is a social media thing that you do?
I rap.
Okay, but you rap. What's the social media, like Facebook, Instagram? What do you use?
Oh, yeah, that stuff.
Instagram. So you got Instagram. You put up your rapping, you can put up, do you have kids? You do, 14 and 13. You can put up pictures of your kids, do you have pets?
Not right now.
All right. You can put a picture of your extended stay, you get back to work, all that. You don't put anything on Instagram that is a message to Miss Kirksey at all. You don't. You don't write a song that says, I can't believe I didn't shoot you last time, Kirksey, because I'm going to next time. Nothing about her that is public, all right?
Right.
You can tell your wife, I can't stand my cousin. But if there's anything public that she could access, that a reasonable person who's pretty clueless like myself, like, oh my gosh, it's clear that that's a message to Miss Kirksey. That's contacting her. Even though you don't send it to her, if you put it on a public space. All right? What are your questions about that?
And my question is, if she does it, because I don't follow her or anything like that. But the whole time I was locked up, my family was harassed. My name was put on Instagram and stuff. Who's calling the police now? Yeah, y'all want to play police games. Then she get up here and she plays the little innocent role. It's cool. Because I love my little cousin. We all human at the end of the day. My problem is when I'm, if she's for say, oh, this is about me, but it's not. You know what I'm saying? Because since I got out of jail, there's been incidents where her dad has pulled a gun on me. And she was around circling me in the car and stuff. Like, I made police report, but none of that stuff came here. It just looked like she's the victim. She's terrified of me and stuff, but this was not going on.
Okay, I hear you.
So I totally understand. I'm just asking, will something be done that way? Because it just looked like
it's all been one way.
You know what I'm saying? And it's not. Like, I want to stay as far away from her as possible.
Good.
You know what I'm saying? Like in real life, like even watching the evidence, like I literally had a phone in my hand, but the recidivist, y'all could say, oh, well, he got recidivist for a gun, so we're going to hit him with a gun. Now give him 10 years prison. I'd rather take this any day. You know what I'm saying?
Yep.
So, but at the same time, right is right and wrong is wrong. And I know it's not about it's about what you can prove. And recidivist and background stuff do matter. So what I'm asking is, will I be protected? Is if they're saying, oh, he's talking about me, and I'm really not.
Yep. So two things in response to that. One, Ms. Wood can assure you, I'm not going to suddenly have some knee-jerk reaction if there's some kind of vague evidence. Let's say you post on Instagram saying, I love my cousins. Okay, that's okay.
Yeah.
I'm talking about something where it's real clear. It's a targeted communication.
Oh, cool.
And it sounds like you're not going to do that. The other thing you raised is real important in terms of you feeling safe in your situation.
Right.
And you may want to explore getting a protective order. That's up to you. Okay. And you can talk to Ms. Wood about that. But there's nothing about the fact that you're the defendant in this case that means you can't enjoy the same kind of protections people get. You get a TPO, you get a restraining order, whatever it is. And so talk with Ms. Wood about it.
Okay.
She won't be your lawyer proactively in that way, but she can connect you with resources so that if you think it's important to get a judge to say, I'm making it up, but that Ms. Kirksey's dad has to always stay 200 yards away from you. If there's a good basis to do that, a judge is going to do that.
Yeah.
And if he doesn't stay 200 yards away from you, then that's aggravated stalking. And then he picks up a real serious case and no one wants that either. And so then maybe that'll stop happening. Okay. Just don't take matters into your own hands. That'll make it worse for you.
Yeah.
So no contact with Ms. Kirksey. You need to stay away from the City Park Apartments. That's the easier one. Just don't go there.
Okay.
All right. No matter, there's no like, well, it wasn't clear what you meant. You don't need to go there. If you got friends there, they need to come visit you.
Yes, sir.
You're going to need to do 100 hours of community service. You need to do those in your first year of probation. I'm not going to require you to be gainfully employed because I know you want to, but right now you can't, and you're going to get there as soon as you can. I'm not going to require you to get your GED. You are a well-spoken, able-bodied individual, and if you decide that a GED is what's holding you back, you're going to get one. I don't need to tell you that, but I don't get the sense it's interfering with your progress in life. Anger management might be something that would help you out, but it sounds like you've already taken the class. If you can provide proof of that, probation will recognize it. If you can't, then they're going to make you take another class. Never hurt anyone to learn something twice, but you'll need to get some kind of proof of completion.
Okay.
I will waive your probation supervision fees for the first 6 months of your probation. After that, if you are still on workers' comp, you should let probation, let me make it easier. I will waive your probation supervision fees as long as you can document that you're on workers' comp. So once workers' comp goes away, you're working, then you're going to pay the supervision fees. It's not like it's $1,000 a month, but it's also not zero. And right now, all of your benefits are going to housing. So we're not going to divert that over to supervision. But once you are able to get back to work, then you're responsible for the supervision fees. I will also set a behavioral incentive date of January 8th, 2029, which is 3 years from now. And what that means is if we've gone 3 years and there've been no issues with you and your cousin, or you and City Park Apartments, all that kind of stuff, then things can become unsupervised, quieter, earlier than they otherwise would. So there are reasons for you to do well, because you can get out from underneath supervision sooner. And that's how I am structuring your sentence. Ms. Smith, anything else from the state?
No, Your Honor.
Ms. Wood?
No, Judge.
All right.
Question.
Is there any way that community service can be lessened? I really do want to go and find a job and actually get paid to take care of my lifestyle. And I kind of can't doing.
Well, but if you spread out 100 hours over the course of a year, you're able to do that. So,
all right, cool.
Yeah, and you may want to knock it out while you're not able to work, because there's plenty of community service that doesn't require you to move your right thumb. So you could take care of a lot of that right now. Ms. Kirksey, do you have any questions about anything that I said? Okay, you and I had a good conversation. If you feel like something's happening that shouldn't, document it as best you can and get it to someone from the DA's office. But you need to make sure that your friends and family know they need to not be messing with Mr. Williams either. It needs to be, I'm not saying it happened. I don't want you to be defensive in any way. You cannot, you're right, you can't, but you can tell folks, you're not helping me, meaning helping you. Okay, you can't. Good, good. I'm not worried about you on your end. It's just maybe people you know, you may want to twist their arm a little.
You know, he didn't have everything
Yep.
happen, so it's me, as far as me, I never made any friends, nothing on my.
Okay, well, I'm hopeful the passage of time is going to make this better. We're coming up on a year anniversary. Hopefully people are moving on in different healthy directions. Okay? All right. I'm curious, how is it between, so your mom is Mr. Williams's mom's sister?
Mm-hmm.
How's that relationship?
I ain't talked to my auntie since, and my mom only got 2 sisters, and it hurt my feelings because I miss my auntie on a regular basis because that's my only auntie I was close to. But of course, you got to choose a side, and your child's side or your nephew's side, I'm gonna choose my child.
Yep.
You know what I'm saying? Got to do that. So it ain't no hard feelings. I love her. I just hate it happen.
They're just different family reunions than there used to be.
I don't go to none now.
Wow. Okay.
I ain't never had one. That was the beginning of one.
All right.
No cap.
Well, no cap here. You guys keep your heads down and do your best to stay out of trouble. Mr. Williams, this is Ms. Simpson. She's with probation. She's going to give you your reporting instruction. I know you know the routine, but listen to her and she's going to give you reporting information. All right?
All right.
All right. I need you to sit tight while Ms. Kirksey's folks leave. And then you talk with Ms. Simpson and we will be on break. We're not going to start till 1. I know I said 12:45, but this took a whole lot longer than I thought. So let's try to be back at 1. Mr. Majeski is back. Do you have any update about the video?
Yes,
deputy, reached out to the victim in this case.
Oh, you don't need, you guys just talk. And Mr. Majeski, just get whatever the answer is. They'll tell me what the answer is and you and, unless it's suddenly what you hear is great, we need to resolve the case, you and, Charlie Daniels can get out of here.
Okay, thank you, Judge, understood. Thank you. That's what I hear, I'll push it forward, I will do that.
Correct.
Thank you, Judge.
Who is still here? Well, here, I got a list. I know we're gonna take a plea with one, so he should not go away. Brandon Baker, is anyone here for Brandon Baker? He can go down. He can go down. There's Sherman, he's a plea. Okay.
Okay.
Do you have Ms. Wood, anyone else back there? Just Sherman? Okay.
Somebody else.
Oh, really?
You didn't bring Pierce up.
No, I didn't bring Pierce up.
Did any of our guys get in the fight downstairs?
No,
Okay. Let me look through. It's not,
Dallas took a plea already.
yeah. Sinkfield didn't go away. Brandon Baker, Pierce, Comer, Burden is here. Twitchell is here. Sherman's a plea. Tyrone Patterson's on bond. Oh, these are all bond people.
So everybody but Sherman. Sherman.
Yeah, but I just don't want, yeah, there shouldn't be anyone else. Oh, right, Octavius, right, he can go. He can go, thank you. Yeah, his lawyer hopped on this, his lawyer's sick, and Wright's eval's not back.
Everybody go but Sherman. And then you gotta come down.
That's like.
Just a sec. All right. Do we want to take stock of where the calendar is yet, or do you want to just wait till we're done with everything before we do that? Okay, we'll wait and do that. We're going to kind of do that. Duranta Jones, were you able to reach him?
So, Judge, before the last couple of pleas, I had texted with him. And when I tried to call him during the break, because I was still doing some last minute negotiating, I was not able to reach him.
Okay.
I can keep trying. I don't know if he's asleep or what, but I'm happy to keep trying.
No. I just want to update on whether you thought he might be able to connect with us this afternoon. We can do it another time. Hopefully he'll just keep getting better.
Yes.
Okay.
We do have an announcement about the lot of sexual.
Okay, I'm about to get there. I'm flipping through. Mr. Burden is here. What's the plan with Mr. Burden? Plea. All right, we'll do that soon. Mr. Twitchell. That was, I think you had referred to it as an open plea.
Yeah, or not negotiable.
Okay.
I would like to come and speak with you, this day.
Oh, the three of us need to talk.
Yeah.
Okay, we'll do that in a second. And then Sherman is still a plea, Mr. Sherman.
That was ready, Jeff.
Okay, and then what did we end up telling Mr. Majeski about the existence of the Ring video?
So, we were unable to get in contact with the victim.
Okay.
I did inform him that I left a very detailed message this morning. And once we receive word, we will reach out to him.
Okay.
But I will say, Your Honor, that we also talking about possible negotiated plea with Attorney Majeski as well.
Okay, I think I excused them for the day. So that wouldn't be today, but I'll make a note to stay in touch with you two and Mr. Majeski. I mean, if it exists, great. If it doesn't, we need to move the case along. It's been, I don't mean it in a wrong way, but it's enabled him, Mr. Majeski, to drag the case out. It's like, where's the video? Where's the video? And it's time to say there isn't, or here it is. And now what are you going to do about it? Because he keeps saying it's dispositive. Well, okay. Ring video. Okay. That is it. So we need to talk about Mr. Twitchell. Well, I thought it was a plea. There doesn't need to be a plea. We've got Monday and trial. I'm just curious what we need to talk about.
Yes, Your Honor, so, we've been taking lead on this case, and, we both are in different trials in different parts of the state come Monday, so we won't be able to come back here to do the plea. And, since he's been handling this case, he would like to be present and do the plea himself.
Mr. Aptwood.
Mr. Aptwood, that's right. He is the counsel. I'm here filling in basically.
Okay. Where is he now?
That's a great question. They never tell me. I can call Allison and see if she can tell me.
Okay. Why don't you find out where he is? And we'll see if he can be here today.
Okay, I'll call.
Great. Thank you. With that, what should we do next? Oh, well, I forgot Mr. Sinkfield. Okay, we'll do that. But Mr. Sinkfield, Mr. Hudson was here. Is he coming back? Okay, but he said he's coming back. Good. And was Mr. Hudson talking with you, Mr. Miller, or with you, Ms. Smith?
He was talking with me, Your Honor, but I do not believe, based on my discussion with Attorney Hudson, I don't believe it will resolve today.
Is it, okay, then I need to hear from him, if that, we could add it to the trial calendar, or if he is here just to try to work it. I don't know if he is now the full-time lawyer on it or what.
Based on my discussion with him, he was just filling in for today.
That was my sense. Okay. All right. Well, when he gets back, we'll explore that. Deputy Gordon is asking that we do Mr. Sherman.
Yes.
Yes, that's my request too. And he has family.
Okay, let's do that. Is that all that we have? Is Mr. Sherman the last person? Okay.
And she says, just ask me, okay?
Good afternoon, Ms. Rivers. You ready to get rocking and rolling again?
Yes, I am. Good afternoon.
Great. Then we'll get on the record with positions 16 and 17 from the trial calendar. Winfred Sherman is the defendant in both. It's 25 SC 002841 and 002842. Ms. Wood represents Mr. Sherman and is here in court with him. Ms. Smith is representing the state. Hello again, Mr. Sherman.
How you doing?
Well, we'll see in a little bit. It sounds like we're going to try again with pleas. Is that correct?
Yes.
Okay, you know the process. We got 98% of the way through pleas last time. But we need to start that all over again because time has passed and we want to make a good, clean, safe record. Ms. Smith, were you the one who handled the plea before or this predates you? All right. I don't know if it was Ms. Davis or Ms. Dilligard, but it was a different prosecutor. Ms. Smith is the prosecutor on your cases now. She'll put you under oath, ask you questions that are very similar to what you've been asked before, and we'll see where this leads us. One thing that's different this time around is that if these pleas don't go through, then we'll see you on Monday because we've got a jury coming in on Monday. We have a trial. You have been in jail for a long time, and we're going to get closure one way or the other. Either we resolve them by way of a plea today, or we get a jury in here, they hear the evidence, and they decide guilty, not guilty, and we go from there. Okay? And whatever the questions are, whether it's from me or Ms. Smith, make sure you answer out loud. You're welcome to nod your head or shake your head, but the court reporter only takes down the spoken word. Okay? Great. Ms. Smith.
Yes, Your Honor, thank you. Mr. Sherman, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Winfred Sherman.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given today?
No.
How old are you and how far have you gone in school?
4410.
You're 44 and you went through 10th grade?
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her statements?
Yes.
Excuse me.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
And do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So wait.
Mr. Sherman, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants relating to these charges. Are you aware or your attorney aware of any outstanding warrants?
We are not.
Okay. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 2 with balance probated?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with another crime in the future, that this plea may be used to enhance that sentencing?
Yes.
Are you currently on probation?
No.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be like from a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you would be charged with another felony offense?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these crimes, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands these rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Sherman, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea today?
No.
As to indictment 25 SC 002841, how do you plead to count 1, aggravated assault, count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies, and count 3, possession of a firearm by a convicted felon?
Yes.
Is he guilty?
As to indictment 25 SC 002842, how do you plead to count 1, aggravated assault, count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies, and count 3, receipt, possession, or transport of firearm by a convicted felon or felony first offender?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Freely.
Is it made freely and voluntarily?
Yes.
Okay. Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you also understand that you have to complete that within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Okay. Thank you, Mr. Sherman. Your Honor, the facts of this case, I'm going to do each by the different indictments. So first, starting with the indictment ending in 2841, the facts of the case the state would have been able to prove if it went to trial was that on May 20th, 2024, Atlanta Police Department officers responded to a person shot call at a Chevron located at 2656 Donald Lee Holloway Parkway. When the officers arrived, they were not able to locate the victim, but after a callback, they received notice that the victim was at a location at 2551 Baker Road. The officers then went to that location and spoke with the victim, Darnell Green, who indicated that he was at the Chevron to buy some cigarettes when he got into an argument with the defendant in this case. And when they got into that altercation, the defendant then pulled out a gun and started to shoot at the victim. The victim then noticed later, once he started running, that he was shot. At that point, the officers then filed warrants or took out warrants against the defendant for aggravated assault and firearm during the commission of a felony. And then for the facts of the case ending in 2842, if this case would have gone to trial, the state would have been able to prove that on May 24th, 2024, Officer Jeremy Smith reported to a Chevron located at 2656. This is the same location as the incident before, 2656 Donald Lee Holloway Parkway. He arrived following a person shot call. The officer when the officer got there, he was told by a Kanye Britt, a witness, that a male had been shot and was laying in the parking lot of the Chevron. The victim was Willard Marshall, who indicated to the police officers that he was in the store to buy something, and that the person who he was with got into an argument with the defendant in this case. The defendant then took out a gun and started to shoot at them, and the victim was then shot. He ran from the location, however, he did return, and that's why he was laying on the ground at that Chevron. At that point, the officers did take out warrants for the defendant, and once he was picked up for both cases that happened, I believe, 4 days between each other, he was arrested for these ag assault charges. And those are the facts of the case regarding the negotiated plea between the state and the defense. We've agreed for both the indictment ending in 2841 and 2842 to run concurrent. Regarding the count in the charges in the indictment ending in 2841, we've agreed to a sentence of 5 years to serve 1 for count 1, and for count 2, 5 years to run consecutive, and for count 3, 5 years probation to run concurrent with count 1. For the indictment ending in 2842, the recommended sentence is 5 years to serve 1 for count 1, 5 years probation to run consecutive for count 2, and 5 years probation to run concurrent with count 1. So counts 1 and 3 will run concurrent.
So at the outset of the conversation, you said 10 serve 2. Just now, the sentences would be 10 serve 1.
Oh, no, that's my mistake. I meant 5 serve 2 for the count 1.
Okay.
Count 1 in the indictment ending in 2841 will be 5 serve 2. And in the indictment ending in 2842, count 1 will be 5 serve 2.
Okay. So a total of what you said at the very, very beginning, which was 10 serve 2.
Yes.
Got it. And what kind of conditions?
For the conditions, we're asking for a Fourth Amendment waiver for the defendant to stay away from the incident location, for the defendant to have no contact with the victims, forfeit firearms, and no further violations of the law. And that'll be all from the state.
Do you have in your notes what was recommended? This case was almost a plea in July of last year, July 18th. So before your time, but I'm curious if a colleague made any notations indicating what the recommendation was back then.
Yes, someone told me
And hearsay is okay.
Judge, I just want to I forwarded the background to Ms. Smith on this case. And then also, so this negotiation that we're doing was done between me and Mr. Sperry. And I also forwarded that whole conversation. So Mr. Sperry and Ms. Smith were looped into the background of this case.
Okay, good. No, I'm not suggesting you've done anything negotiating with the wrong people. It's all good. My question is, I recommended a sentence before, and I'm trying to refresh my recollection as to what that was. And Ms. Nelson is helping out. I thought that might be in the DA's office's notes. So that's all. Why did you change your recommendation? The state is free to do that.
Would you like for me to tell you what it was?
Sure. I'm taking data points from all over. I think I'm going to get it from Ms. Nelson, but why don't you start?
It was a 10 serve 5, Judge.
Huh. Okay.
And Judge, just for full candor, the agreement between myself and Mr. Sperry when we were speaking on Monday was that the recidivist C section would be left in place so that the remainder of what time he has left on the sentence would be done day for day.
Got it. So I've got some notes here that say you had requested 10 to serve 1 back in that whenever we were.
That's right, Judge.
Okay. But time has passed and here we are. Okay. But I was going to ask Ms. Smith about the recidivist notice. What you, Ms. Wood, and Mr. Sperry talked about was keeping the C in place so that the 2 years was in fact to the door too.
Yes.
Okay. Okay. Anything else from the state side?
No, you're.
Ms. Washington, can you share criminal history information, please?
Yes, Your Honor. There are 23 arrest cycles. There's a 2006 felony conviction for aggravated assault and possession of a firearm by, an additional 2006 felony conviction for possession of a firearm during, a 2005 felony conviction for possession of a controlled substance, 2003 felony conviction for theft by taking, false imprisonment, and obstruction of a law enforcement officer. Also, a 2005 felony conviction for possession of cocaine and possession of marijuana with intent to distribute. A 2002 felony conviction for purchase, possession, or sale of marijuana, battery, and willful obstruction. A 2002 felony conviction for possession of cocaine, and a 2000 felony conviction for possession of cocaine with intent to distribute. Nothing further.
Thank you. Mr. Sherman, of all those convictions, what's the longest jail sentence you got in connection with those that you can remember?
I think it was,
I mean, some of them can't have been very long because then you were out and you got another case and you got another case. But then in 06, that's like everything went quiet after 06. And sometimes that's because people started handling their business differently. And sometimes it's because a judge gave them 50 years and you don't pick up new cases when you're down the road.
I did a year before I caught the 18 months on 2006.
Okay. All right. Ms. Wood.
Yes, Judge. So as you remember, Mr. Sherman has been eager to accept responsibility since he made his way into this courtroom. He's been in custody now for 593 days. So he's been in since May 25th of 2024. So he's nearing the 2-year mark, Judge. I am not sure. We've not personally had contact with either of the victims in this case. I will note, I don't have any information about any medical treatment. I don't know how severe it was, but as we all know, it could have been very different when a gun is involved. So we're acknowledging that. We are just asking that you accept our negotiated resolution in the spirit of justice and judicial economy, Judge.
Okay. Mr. Sherman, anything you want to add?
So,
okay. So there's a recidivist notice that was filed in both cases as an A and C because it's more than 3 felony convictions. And it sounds like in this case, the state is saying that the recidivist notice is staying in place. That was part of the negotiations. Is that correct?
Yes, sir.
Okay. All right. Well, Mr. Sherman, I find there's a factual basis, like I did last time, for your 2 pleas. I don't know what was going on in May of 24, but you and the Chevron station and your gun were a bad mix. And I guess people were just saying the wrong words to you, but you were shooting the place up. I also find that your pleas are knowing and voluntary. Knowing means you've understood what we talked about. Any questions about anything?
no, sir.
Okay. And voluntary means that no one's forcing you to enter this plea, but that you've decided instead of going to trial on Monday and having the jury hear about all this, you'd like to step forward and enter a plea. Is that correct?
Yes, sir.
Okay. Ms. Wood, I'm sorry, I didn't mean to interrupt. If it's related to Mr. Sherman.
It is, Judge.
Okay.
Just confirming, because I think if we leave the A and I don't know if it's possible to do this because I haven't done this before. Is it possible to just do the C provision of the recidivist notice?
So the state has flagged both. They can unflag one. They have the option to pursue some, all, or none of the provisions. It's been a minute because we don't typically end up, the state doesn't typically end up enforcing them. But with A in the mix, and this may have been the hush whispers. I would need to sentence, just as an example, with count one in 841, I need to sentence Mr. Sherman to 20. It wouldn't have to be 20 to serve, but it would need to be 20. And so if I were following the recommendation, then it would be 20 to serve 2. I could suspend a bunch of it, but the sentence would have to start with 20. What I had heard you say was that Mr. Sperry was requiring, as part of the negotiations, that the subsection C remain in place, which does exactly what you said. Whatever prison time I impose is non-parolable. And so if I followed the recommendation, that would mean that Mr. Sherman needs to do 2 full years, getting credit for all the time he's served. And so there's kind of light at the end of the tunnel because he's 100 and something days away from getting to 2 years.
Yes, Judge.
So it sounds like actually what we're proceeding with is a recidivist status of 1710(7)(c) only.
Yes.
So that whatever prison time I impose, Mr. Sherman's doing all of it, but I'm not required to say, well, we got to start with a 20 for the aggravated assaults.
That's my understanding. I was just.
Okay, is that your understanding, Ms. Smith? Okay,
Thank you, Judge.
thank you. Ms. Wood, can someone in my office sign the 2 indictments on your behalf?
Yes, of course. Thank you.
Ms. Smith?
Yes, Judge.
And Mr. Sherman, can we sign the 2 indictments for you indicating you're guilty, please?
Yes,
All right. Who do you have in court here today?
my mother.
Your mother. Hey, Mom, how are you doing? You're welcome. Any idea what was going on in your son's life back in May of 24?
No, I don't.
This was rough stuff.
No, that was surprised me.
Yeah, okay. I think Ms. Wood is right that none of this is good, but Mr. Sherman is fortunate. Obviously, Mr. Green and Mr. Marshall are fortunate that the way they got hit, it didn't hit the wrong vein or the heart or this or that. And so we're talking about very discrete numbers and single digit numbers as opposed to much more serious sentences. All right. Mr. Sherman, I'm going to sentence you in 25 SC 002-841 on count 1 to, I'll make sure the math works out here, to 4 years to serve. Count 2 has to run consecutive, and that'll be 5, and that will be probated. And count 3 will run concurrent with count 1, and that'll be 4 years to serve. In the case ending in 842, it's the same sentence. So 4 years to serve on count 1. Count 2 has to run consecutive, and that'll be 5 years probated. And then count 3 is 4 years to serve. That runs concurrently with count 1. And both the cases run concurrently with each other. So it's one sentence of 9 years to serve 4 years with the balance probated. When you get out, you need to stay away from that Chevron station on Donnelly Hollowell, if it's still there. No contact with Mr. Green or Mr. Marshall. If there were any firearms seized from you when you were arrested, you forfeit those. And you'll have a Fourth Amendment waiver, meaning that while you're on probation, if probation thinks there's a good reason to search your car or your bag for some reason, they don't need to have a warrant in order to do that. And importantly, you get credit for all 593 days that you have already served. Ms. Smith, anything else in connection with Mr. Sherman's cases? Ms. Wood?
No, Your Honor.
Okay, thank you. And Mom, it may be Ms. Sherman, I don't mean to call you Mom. I appreciate you being here all afternoon as well. I'm sorry you had to be here so long, and it was important. It actually had impact on how this played out that you were here. So thank you for being here.
So can I ask a question?
You sure may.
So, I got law. So, what does it have to do? I mean, is it He had to do 4 more years of.
He has to do 4 years minus all the time he's already done. And so I'm not quite right about this, but he's done more than 1.5 years. So subtract the 1.5 from the 4. So he's got 2 years and some change remaining.
So how much probation he had?
5 years probation after that.
And 4 years to do.
Correct. But he's already done of those 4 years, more than 1.5 years. Okay?
Thank you.
You're welcome. So what's the update on Mr. App?
Trying not to sound like my feelings hurt. I can't get in touch with anybody, nobody's called me back. I looked at our calendar. He's either in Henry County, Polk County, Cherokee County, or Gwinnett County. I don't know where. I'm sure he's somewhere tied up, so he's not answering his phone. But I think he took our main paralegal with him to assist. And I don't know where our other paralegal is. She's answering the phone either.
Okay.
So I am at a loss, Your Honor, and don't know what to say. I figure he instructed me to not take the lead on this and let him handle the lead because it's his case. So I have to respect that as an associate attorney. And but I appreciate the court's position too. This case was brought in and announced, and I was ready to go. So
Right. And I don't know that there's a conflict from Mr. Apt that would require me to not go forward today. Mr. Twitchell, tell me not about your case, but what your concern. Here's my understanding is that the state has an offer, a recommendation. It's something you're not real interested in, which is okay. And so whether it's Mr. App or his colleague, someone on your behalf is going to say, here's what the situation should be for Mr. Twitchell, something different from what the state's saying. That conversation is going to happen at some point. It doesn't sound like you're going to trial unless you changed your mind and said, actually, what I want to do is go to trial, which is okay. But I just need to get clarity on which of the two it is. It's, no, I want to go to trial. That's not what we're doing today anyway. Or it's, I don't want the jury hearing about this. It's not going to end well for me at trial. I would like to get a better offer from the state. It's not going to happen, and that's okay. So I'm going to do what we call a non-negotiated plea.
I really want to speak to Jay more because I haven't really been able to talk to him. He's close to my bin. So as far as what he's going to do.
Oh, meaning you wanted to talk with Mr. Apt about which of the two options makes the most sense?
Yes.
Okay.
Or whether to go to trial.
Right. We're saying the same thing. You're saying it better. Okay. I also don't have a conflict notice from Mr. App, at least not in the docket, about next week. I don't doubt you when you say he is always on trial in 1,000 places.
oh, believe me, I know. It's we're always doing crisscrossing the state, it feels like. I think I'm gonna be in Henry doing a murder case in 2023. I think he's got a case. Where else should we go? I heard from him maybe. Maybe Clayton County. There were 3 in the air, and I'm waiting to see which one I go to. So I don't know where he's going. I don't know why the conflicts haven't gone out. I saw some filed yesterday. I don't know if one was filed.
Okay, it could be. If it hadn't hit the docket yet, that doesn't mean he didn't file it. Mr. Abadi, what are your thoughts about how we move or don't move forward with this?
That's at the discretion of the court. I mean, I'll be ready anyway.
Right, but I don't want you to have to get ready for Monday if we don't, I don't know that Mr. Apt can't be here. Again, I'm not doubting you, but he doesn't have a legal basis to not be here on Monday right now. But I don't want you spending your weekend doing that. We're getting the officers ready and there's a family out there. Okay.
Last time I spoke to Mr. App, he indicated that this would be a plea.
Okay, that was what the sense that I've always gotten when you and he and I have talked about it, is that it might not be negotiated. He might not get you to where he wants you to be, but it's not something that will go to trial. But Mr. Twitchell, 100%, you need a chance to talk with him about it. I'm not suggesting that won't be what happens. But we need to move this along. I guess my project is to get in touch with Mr. Apt, so I'm gonna work on that. You should consider it a possibility that you need to be here Monday morning. Okay? And that will hinge on whether we can get Mr. Apt here on Monday morning. And that doesn't mean it has to be a trial. It may be that when you and Mr. Apt are able to speak, he persuades you of the wisdom of the route that he's told the state he wants to take. And then we can take your plea on Monday morning. But I'm not excusing you yet from needing to be here on Monday morning. Okay? So if you don't hear anything from anyone, be here at 9 a.m. on Monday morning. My hope is that someone from Mr. Apt's office gets in touch with you to say, actually, it's changed because of conflicts. I don't need you to come down here by yourself. If there's not going to be a lawyer here, it's a waste of your time to be here. So I'm going to see what I can do to get Mr. Apt here on Monday.
Thank you, Your Honor.
What we got to do. All right. So you, lawyer and client, are excused, and I guess that's it for you. Okay.
I can't see on the Zoom. Is there an Elizabeth McBurney still on Zoom?
Thank you, Your Honor.
You bet. No, I didn't ever see that name on there.
It's the mom that they can shoot, sign on after lunch.
Oh, in Mr. Twitchell's case? Okay. All right. Hey, hold on one second on the Twitchell side. I just got an email.
I also saw something change on the calendar. It was like there's another trial scheduled in this courthouse for next week somewhere. I didn't go somewhere else. Maybe he can come in during a break and do like.
Right. So his leave is over. He had leave through the 3rd, and then he has leave on Friday, but just Friday. So then he's back. So he doesn't have a leave issue for trial next week. It would be what you're describing, which is he's got 8 other trials. But I haven't seen that conflict yet. This is just his leave of absence, which doesn't cover today, and it doesn't cover next week. All right. Now you should go before another email comes.
Okay. Thank you, Connor. Do you have a comment? Richard?
I didn't bring it, but I can.
I haven't, but I almost did. You should be here.
Sure.
All right, thank you. Thank you, Your Honor.
You bet. Ms. Wood, what's next?
Burden.
All right, Mr. Burden. Mr. Burden, if you don't mind coming and sitting next to Ms. Wood, it's going to work better for acoustics if you're there. Thank you. So is Mr. Miller doing anything today, or are you making you do everything? Mr. Hudson, you're back.
Yes.
So give me an update, please, on Mr. Sinkfield and where we're going. I look at the charges and I think, why are we not able to work this out?
Absolutely.
But it takes 2 to tango.
I talked to my good buddy, Mr. Miller. I know this is Ms. Taylor's case.
It is.
And you know she's gonna know.
I do. And so I was very grateful that she lined you up and very grateful that you were willing to come in. So I'm not assigning these cases to you or anything like that.
I just need an offer.
Oh, you don't have an offer?
No.
Oh. Well, why don't you and Mr. Miller talk a little more while, you're good with that? While Ms. Smith handles this plea? Because if I look at the charges and the ages of the cases, it seems like a kind of case, Mr. Miller and Mr. Hudson, you're looking pretty sharp these days, Mr. Hudson? You're taking good care of yourself.
I lost 90 pounds, yeah, keep it up.
All right, I don't know, you guys share your secret, but good job. That means you'll be around a little longer.
Yes, Lord.
Just kind of excuse.
Yeah, thank you.
I'm well next week whenever it's draft is available.
All right, thank you. All right, let me get. There he is. Okay, you ready to go? This is position 12 on our trial calendar, State versus Antonio Burden, 25SC002-362. Mr. Burden is in court with Ms. Wood. Ms. Smith is handling things for the state. Mr. Burden, Ms. Wood tells me you're ready to move forward with a plea. Is that correct? Yes, sir. Okay, well, we'll do that. Ms. Smith is going to put you under oath, ask you a bunch of questions. You need to let Ms. Wood and or me know if you've got any questions, okay? All right. Ms. Smith?
Yes, thank you, Judge. Mr. Burden, may you raise your right hand? Do you swear or affirm that the testimony you shall give in the matter heard
Before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Please state your true, correct, and legal name for the court.
Antonio Burden.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine? And is there any medication that you would normally take that you haven't been given today? How old are you and how far have you gone in school?
39, 12 grade.
Did you finish high school or just get to 12th?
At 12.
Are you able to read, write, and understand the English language? Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment? Do you need more time to discuss your case with your attorney? Are you satisfied with her services?
Please come out. I can't hear the defendant.
Okay. We're gonna move the microphone and then, are you as close to the table as you can get? Great, and use an outside voice. Do you have kids?
Yes, sir.
If you're trying to get your kids' attention outside, talk like that.
Counsel, are you satisfied your client has a full understanding of this proceeding? Also, counsel, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So wait.
Mr. Burden, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not.
Mr. Burden, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing?
Yes, ma'am.
Are you currently on probation?
No, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, the right to hold office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment. Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you would be charged with another felony offense?
Ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yeah.
Do you also understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, and the jury would be told they cannot use your choice against you, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial. Counsel, are you satisfied your client understands these rights they'll be waiving by entering this guilty plea?
I am.
Mr. Burnett, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25SC002364, how do you plead to count one, trafficking in cocaine, illegal drugs, marijuana, or methamphetamine? Count 2 through 4, possession of a firearm or knife during the commission of or attempt to commit certain felonies. And count 5, possession of a firearm by a convicted felon.
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? And do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yeah.
And do you understand that that needs to happen within the 30 days of today? Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
It's not.
Okay, thank you, Mr. Burden. Your Honor, if this case would have gone to trial, the state would have been able to prove that the defendant here was under a undercover operation with the Atlanta Police Department. I believe it was Atlanta Police Department. A confidential source came to the Atlanta Police Department and stated that there was someone who was selling illegal narcotics out of the bottom apartment of 1350 Mason Turner Road, Northwest Atlanta, Georgia. The anonymous caller stated that the apartment was located toward the back corner in the main center of the parking lot in the apartment complex. So during this time, the officers put the apartment under surveillance and after they received that tip. So the officers between the dates of April 2nd to April 5th conducted surveillance of this apartment complex. During that time, they were able to find, or they surveyed and saw multiple people walking up to the home, entering for a short amount of time and then leaving. And it was heavy traffic of cars. That confidential informant then started to have or conduct sales with the defendant in this case, where they purchased marijuana. They also purchased, I believe, cocaine and different other narcotics from the defendant. Between the dates of April 11th and April 14th, the confidential source conducted also another controlled narcotics purchase at the same location of 1350 Mason Turner Road, Northwest, apartment E2, where the defendant lived. At this point, after being under surveillance, the officers then filed or put out for a search warrant to search the home. At this point, they executed a search warrant where they found narcotics, guns, and then a warrant was placed for the defendant's arrest. The GBI lab confirmed 28.5 grams of methamphetamine that was conducted or taken from that search that they did at the home. At that point, the defendant, when the arrest warrant was executed, was arrested for the charges that are on the calendar here today. And those are the facts of the case regarding the negotiated plea between the state and defense. The plea for, the recommended sentence for count 1 is going to be 10 years probation. The recommended sentence for counts 2 through 4 will be 5 years to run consecutive. However, those will be suspended. And then for count 5, that is a 5-year probation sentence that's recommended for count 5 to run consecutive to count 1. We do understand that count 1 has a mandatory sentence. However, the prosecution and defense has agreed to deviate from the mandatory sentence of count 1. And that's mostly based off of the defendant's medical history. I did speak with Ms. Wood about his current health diagnosis and status of his health. And she told me that he's paralyzed from the waist down for 8 years now. Was very sick at the time he was incarcerated, to the point where he was spending his time at Grady so they could care for him.
When you say the time he was incarcerated, some others, he was only in for 16 days for this case.
Yes, during that time. He was
During those 16 days, he had to be at Grady.
Yes.
Okay.
Also, in addition to being paralyzed, he gets infections quite often and has a home nurse that visits him around 3 times per week to help him out, make sure he's not getting infections and things like that, and to change out his bag also that he has placed on his stomach. Also, Your Honor, when I was just talking about that incarceration time when he was at Grady, I have a letter from the doctor I've showed Miss Wood, sorry. I showed Miss Wood, and basically that's why the state has agreed to deviate from that mandatory sentence, because we believe that the taxpayers' dollars will be paying more for him to survive in prison if he goes in his health condition versus being able to give him his probationary sentence.
So, what prevents him from staying in this line of work if he knows he's never going to have to go to jail because the state thinks he's just not well enough to be in jail?
I think the biggest thing with that is for the defendant to, over this course of being on probation for about 10 to 15 years, to not to get into any other trouble, and to make sure that his health is improving during that time.
Okay.
I don't think I mentioned special conditions of probation, but we were going to ask for Fourth Amendment waiver, for there to be, of course, no guns or drugs around the defendant, and for there to be no other violations of the law.
All right. Got it. Your office filed a recidivist notice. I'm assuming you're withdrawing that for purposes of this plea?
Yes.
Okay. Ms. Washington, criminal history information, please.
Yes, Your Honor, there are 18 arrest cycles. There was a 2016 felony conviction for possession of a controlled substance, possession of marijuana less than an ounce, and 2 counts of unlawful manufacture, distribution, or possession with intent to distribute that appeared to be charged as a misdemeanor. There's a 2015 felony conviction for 2 counts of possession with intent to distribute, possession of heroin, and unlawful to come inside of guard lines to deliver a controlled substance to an inmate, disorderly conduct, and criminal trespass. There is a 2011 felony conviction for possession of marijuana with intent to distribute and misdemeanor willful obstruction. 2008 felony conviction for theft by receiving stolen property, misdemeanor fleeing, and possession of marijuana less than an ounce. A 2008 felony conviction for possession of a firearm during, carrying a pistol without a valid license, carrying a concealed weapon, giving a false name, and possession of marijuana less than an ounce. In 2005, there was first offender treatment for terroristic threat, possession of a firearm during, and carrying a pistol without a valid license. No sale date was listed. Nothing further.
Thank you. Ms. Wood?
Yes, Judge, thank you. So I do just want to let the court know there was a co-defendant at one point. That case was dismissed outright by the state. So I do want to let the court know that Mr. Burden is here. He's accepting responsibility. And I believe, if I heard correctly, this will be, and I know it's going to be a trafficking conviction on his record. I think everything else has been either with intent to distribute or simple possession. So that in itself is an incentive for Mr. Burden to do well on probation, because as you know, if he gets more trafficking convictions, it does not bode well for him to get another such reduction. So as to your inquiry to the state, I just wanted to add that, Judge. He does have significant health issues. He's one of my clients who, when he was in custody this most recent time, the jail was losing it because they were unable to actually care for him. As you heard from Ms. Smith, he does have significant health issues and has the home health nurse that comes because he's got different inserts in his body, Judge, that have to be taken care of by medical professionals. So we would just ask that you accept the state's recommendation in this case.
Okay. Mr. Burden, you still at Mason Turner or you somewhere else?
Sir, I never stayed there.
Oh,
I never stayed there.
that was your workplace?
No, I just got caught up, man.
Uh-huh. Okay. Where? So I've got a Bolton Road apartment. Is that home? Okay. Who stays there with you?
Me, my 3 kids, and my girl.
Okay. How old are your kids?
13, one finna be 14, 13, and 10.
Okay. So they're all in school?
Yes, sir.
And is it their mom who stays with you?
Yes, sir.
Does she work?
Yes, sir.
What does she do?
What is that? Home health, caretaker.
Okay. So like someone who's taking care of you, she's just not the one she works somewhere else. Okay. And then do you get SSDI?
Yes, sir.
And is that what helps pay for the person who cares for you?
They pay the Social Security, you saying?
Yeah.
Yes.
Okay.
Yes.
How long ago were you shot?
2017.
Okay. Was someone ever prosecuted for the shooting?
I don't know. He locked up, but I don't know if he got prosecuted.
Okay. That person still locked up or just was locked up back then?
I don't know if he's still
All right. He's not bugging you anymore. Okay. Do you have any questions about anything we've been talking about?
No, sir. I know 10-year probation. It's all right, but I was okay.
That's probably a good thing for you to do. 10 years probation is a while, but is a whole lot less burdensome than getting locked up for a while. My question that Ms. Wood has helped answer is, how does this sentence discourage you from getting mixed up in whatever you were mixed up with in the past? Because the state might be much less interested in giving you probation and stepping back from the mandatory minimum if you were fit and healthy. And it's a valid concern for people to ask, well, why is prison only for fit and healthy people? It should be for people who have broken the law, which trafficking in methamphetamine and having guns is doing. But this time around, we're going to see how a bunch of probation works. If you are someone who really isn't wrapped up in this stuff you say you're not really wrapped up in, then being on probation shouldn't be a big deal. You can call in and all that kind of stuff. So I know you'd rather not have someone looking over your shoulder, but that's a better setup than your kids having to come visit you down at Valdosta State. All right, well, Mr. Burden, there's a factual basis for your plea, and I find that your plea is knowing and voluntary, so I will accept it. Ms. Wood, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Ms. Smith?
Yes, Judge.
And Mr. Burden, can we electronically sign your name to the indictment? So the state has moved to deviate down from the mandatory minimum, which they are authorized to do. And I will sentence you on count 1, which is still a trafficking count. And I want to be clear, it was just barely trafficking. If someone had sneezed and some of that meth had blown away, it might not have been trafficking. But 28.5 is past the 28-gram threshold. It's still a fair amount of methamphetamine. But for count 1, so I want to make sure I follow this. Some of the firearm sentences have to run consecutive. So is it 10 years probation plus 5 years suspended?
Yes.
Okay, that was what you were recommending.
Yes.
Okay, all right. So count 1 is 10 years. Count 5 is 5 years. Those will run concurrently with each other, and they will be probated. Counts 2, 3, and 4 are all 5 years consecutive to count 1, and they're running concurrently with each other, but consecutive to count 1. And so technically your sentence is 15 years, 10 of which are on probation, and then the last 5 are suspended. And your probation, if you're doing fine, your probation will be unsupervised and maybe even closed out long before the 10 years. But that's on you. It depends on what you do at age 39 with your time. And we'll see how the probation plays out. There's a mandatory $200,000 fine for this level of trafficking. I don't know that you can waive that. I know you can modify the sentence to make it what you did. We don't deal with trafficking a whole lot. Do you know anything about the fine? Do you think, Mr. Miller, that can be part of the downward departure that the state is seeking? They can downwardly depart with the fine as well?
That is my position.
Okay, and that is your request?
Yes.
Okay, all right. Then I will not impose, because the state is downwardly departing, the $200,000 fine. And so it sounds like it'll be two special conditions of your probation. One is you stay away from 1350 Mason Turner. Two is that you're going to have a Fourth Amendment waiver, which means if probation thinks there's a good reason to do it, they can come on, they're going to knock first, but they can come on in your place and look around and make sure no guns, no drugs. And by no drugs, no prescription. You can have prescription drugs. If you need to take medication as you're working through your health challenges, that's fine. But if you're not prescribed Percocet, there shouldn't be a bottle of Percocet in there. And they're not going to prescribe cocaine, so there shouldn't be cocaine in there. Those will be the two special conditions of probation. The only special condition of your suspended sentence, those last 5 years way down the line, are simply that you obey the laws of Georgia, the other 49 states, and the United States. Your current address, is it in Fulton County?
Yes, sir.
Okay, I guess I do that. It was on Bolton. So you will be supervised by probation out of Fulton County. And you may. Wow. Oh, that's Mr. Jones. He got on.
Yes.
Okay. I don't know if you'll need to report the very first time. Ms. Simpson can talk to you about that. I'm just flagging that because of your mobility challenges. They will work with you on terms of they meet you where you are, or it may be easy enough for you to get down to the convenience store near your place and they can meet you there or something. But it may be for the very first time you have to go to their office, which is about 2 blocks from, you've been on probation before?
Yes, sir.
In Fulton County?
Yes, sir.
Okay. Well, way back when it was down off Riverdale or something. It's now just a few blocks from here. Okay. Ms. Smith, anything else in Mr. Burden's case?
No, Judge.
Ms. Wood?
No, Judge. Thank you so much.
Mr. Burden, any questions?
Yes, sir.
Okay. Ms. Simpson, you want to just meet with him outside? Does that work? Okay. Then you are done for now, Mr. Burden. Ms. Simpson will meet you outside. She's going to get you to sign something that is you acknowledging when you have to report or how you're going to report to probation, but she'll talk to you about that. All right. That's it. Do you want to talk with Mr. Jones? He's good?
We're good, Judge.
Okay. Ma'am, are you here with Mr. Sinkfield? Is he talking with his lawyer? Okay, they can stay out there. As long as they're talking, that's good. We got one more plea we can do before we got. Okay. All right, well, we're gonna tackle Mr. Jones since he's good enough to be on the phone.
Yes, Judge. This is a non-negotiated misdemeanor plea.
Okay. Mr. Jones, are you able to turn the camera on? Are you able to text him?
Yes.
Mr. Hudson, if you want to give me an update, we got someone who we're trying to connect with on Zoom, and while we're doing that, I'm happy to hear from you.
Yeah, I spoke to Ms. Taylor and conveyed the offer that Ms. Miller, where she said she wanted to keep it on the trial calendar. Judge, she did file a motion to suppress
but she hadn't particularized it. But she was like, she wanted to talk to Ms. Alita and possibly work it out. She said in case I come to trial, she said not in a position to help, she wanted to start off.
Let me unpackage all that. Let's start with the motion to suppress. You said she filed one, but it's not particularized, which means there's not a motion to suppress. Okay, and is she now thinking about particularizing it, or?
She said she wanted to speak with the state and come to a resolution, but keep it on the trial calendar.
Okay, well, it is on the trial calendar. Oh, keep the plea offer open. Okay. Do you have any sense, it's now in the docket.
She said 8 weeks, she's gonna leave for 6 to 8 weeks. Not gonna leave, she said, and it's fine.
Wow, okay. Do you know her, notice says that she might be available for disposition of some cases by Zoom in January. We are in January now.
She's actually on Zoom, on another Zoom calendar, so maybe if you could put her on the Zoom, that would be perfect, Judge, and I'll just relay this to her.
Okay, where I was going though is, will Mr. Sinkfield be able to communicate with her during January? Whether it's a meeting, I just want to, if the state's making an offer that to you, Mr. Hudson, seems reasonable, then it probably is going to seem reasonable to Ms. Taylor. But I'm hearing you say she wants to talk to Mr. Sinkfield about it.
Yes, I don't think she want to take, Judge, I think she might eventually go with a non-negotiated plea.
Okay.
She want to be present when we do that.
Okay, but present could be by Zoom.
Could be Zoom as well, Judge, because she's actually on a Zoom call now.
Okay, just not our Zoom call.
Not y'all Zoom.
Okay. But you believe that she can interact with Mr. Sinkfield, whatever her situation is, doesn't mean she can't meet with her clients.
Yes, she can.
Okay.
She can meet with Sinkfield. We was out there speaking with her.
Okay. All right. I guess we'll need to work with her and her office to figure out what that means, because we won't go to trial on Monday because Ms. Taylor can't be here. But then Mr. Sinkfield sort of just stuck. And I guess we'll sit tight. Mr. Sinkfield, tell me how have you been communicating with Ms. Taylor? Has it been phone call, text, both? Okay. And do you know what the state's offer is in the two cases? You don't need to tell me. I just want to know that you know it. Okay. And is that something you want to talk to Ms. Taylor about? It's ridiculous. Okay. Well, it is what it is. You got two different cases. That means the state would have two chances in front of a jury to try to knock you out. So it might be less ridiculous than what could happen if a jury found you guilty. But I don't know how that will play out. So, Ms. Smith, any thoughts as to how you want things to proceed?
I'll reach out to Ms. Taylor, but maybe the offer is to expire in the next 2 to 3 weeks, so we can try to wrap it up.
I think that's a good idea. I mean, I'm not dictating how you do it, but if you keep the offer open, Ms. Taylor is saying in her leave that she can be available through Zoom to take pleas in January. Don't say anything about February. So my thought that we try to see what we can do this month. All right, I'll keep the pressure on. I think that's it. Again, Mr. Hudson, I appreciate you parachuting in to help out. And look who just walked in. My gosh. Okay, Mr. Sinkfield, do you have any questions?
Just, if I'm allowed to say, please take these old cases into consideration.
I am well aware that these are from 2023. One of these is going to be 3 years old in a couple months. So that's all the more reason why, like, can we not close these out? But in defense of the state's been ready for a while. your lawyers made it hard for us to move this along. I'm not blaming her, but some of this is, we can't do it without your lawyer here. So we're gonna keep working on that. Maybe you can work on it as well. All right? All right, you let Mr. Hudson know about that, and we'll try to get you in here as soon as we can.
Doug, do you have an update in January so I can let Ms. Taylor know?
I don't, I need to talk with Ms. Nelson, and we may be in trial next week, and so we'll see.
Okay, Judge, thank you.
All right,
See you later, great seeing y'all.
same. What's going on, Mr. Hiles? Living the life?
Living the life. Living the life.
Dad. Good. Were we able to, Mr. Jones disappeared.
Oh my God.
Is that our last case or is there more?
Yeah.
Okay, well, let's try one more time. But if it's a misdemeanor plea, that does seem like he could come in on Monday as well for a plea. So why don't you text him and see if he's gonna be able to navigate it. Oh, he's back on. We've got audio for Mr. Jones. And we got some video. Let's see if we can. There he is. Hey, Mr. Jones, can you hear me? Can you unmute? Hey, Mr. Jones, can you hear us?
Yes, I hear you now.
Okay. I'm gonna mute you for a second. We should try this another time.
Yes, please.
This Ms. Rivers' head will explode. Why don't you coordinate with Mr. Jones? We're gonna see. Mr. Jones, I need you to keep your phone muted, okay? You're good. Just don't touch any buttons right now. Just lay there and rest. So what I've got for next week, based on all the good work you folks were doing today, is on one of these lists. We've got Silva, Rodriguez, and Bates for next week. We took care of that and that and that. We need to handle Mr. Jones's case, but my thought is we can do that next week. The virtual's fine, he can come in, we'll figure that out, but let's just move the plea to next week and handle it that way. So, Mr. Jones, I'm gonna let you continue to recuperate. Ms. Wood will be in touch with you. Is it safe to say, Ms. Smith, that the offer can stay open since I'm bumping it? So I know it's non-negotiated, but the misdemeanor offer from the state will stay open and we'll just try to knock it out next week, okay? Just hold up one finger if you understand. Excellent, good. You rest and we'll see you soon. All right. As between Bates and Silva Rodriguez, are they both Wood Productions or is one a Rios case?
Rios has, but we'll be sitting together on.
Okay, well, you can speak on her behalf. Is there one that you want to prioritize over the other? Because I'll put the Speedy first. I need to because of that. But
Speed versus state.
You would too? Well, look at that. Okay. I'll still send an email out to everyone, on that. And we'll just be getting ready on both those cases. All right, they're both yours?
Yes.
Okay. Make it a trial. I think that's it. Anything else?
Thank you.
All right. Mr. Miller, I appreciate you spending most of your day here as well, helping put out fires. Ms. Rivers, did you have something?
No. I didn't have anything.
All right. Well, thank you for taking all that stuff down. And Ms. Washington, thank you for covering. I got the sad retirement note. I mean, I knew Ms. Jackson was going, but it's official. I thought maybe over the break she changed her mind and said, no, I can't leave everyone.
No, she's leaving us on the 13th.
Yep. All right. Well, I will definitely pop in for that.
Okay.
Great. All right. Well, thank you for your help today.
All right. See you Tuesday.
All right. Bye-bye. So, Mr. Jones, I'm shutting down the Zoom, but we will see you